Yes.
My lord, I'm seeking leave, my lord, in that matter. My lord, your lordship was, my lord, pleased to, my lord, direct me to bring the copy of the order, my lord, of the state administrative tribunal, my lord, where, my lord, the administrative tribunal has refused to take up my matter, my lord, sitting singly. My lord, that order, my lord, everything I have, my lord.
So there is no division bench in the trial?
No, no, no. For the last,
Chairman,
no, no, for the last 2 years, my lord, there is no division bench.
even there is no chairman also.
There is no chairman even, my lord.
Despite of the order of the erstwhile division bench of this High Court, for appointment of the chairman, no chairman has been appointed.
Show us the order.
There is only one presiding officer at this moment, my lord, for a long period of time. Sayyid Ahmed Baba. My lord, my difficulty is, my lord, there is nowhere to go, my lord. My lord, if the result is declared, my lord, on Friday, my lord, appeal is, my lord, my original application is going to be infructuous, my lord.
Why? You obtained the interim order, it will abide by.
My lord, lots of third party, my lord, there are total 300 and...
Thereafter, you agreed by that order, you came before us. We
Yes,
did
yes.
not disturb that order.
My lord, with the perception that the matter would be
No, not
completed,
with
my
that
lord, by
perception.
December.
It
By
was
December.
hard on merits, and your interim order for staying the entire proceeding was not acceded to.
Yes, my lord. My lord,
How can we help you now?
my lord, with the direction, my lord, that the matter would be completed, original application would
We
be...
cannot direct completion by Friday.
My lord, no, but my lord, the result,
cannot
only
direct-
my lord, declaration of result, my
The
lord.
declaration of result will abide by the matter. What is your problem? A coordinate bench has refused that prayer of yours to stay the selection process.
My lord,
We are bound by that order.
your lordship's, that was your lordship's order.
Very good. It may be my order, but the thing is that how it will solve your problem.
My lord, only difficulty is, my lord, that, my lord, it was also directed that the matter was be taken up, my lord, by December 2021. My lord, 2 years have, my lord, passed in the meantime.
That is another aspect of the matter. But
Lord,
you are wanting inclusion so that you can get an interim order not to publish the result.
my lord,
That supposedly we cannot do because we have already refused that order.
my lord, kindly appreciates, my lord, there is nowhere to go at all. My lord, the tribunal is, my lord, not taking up the matter, my lord.
A leave granted, listed out.
Grateful, my lord.
Shall we or other side?
Yes, 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 certainly, my lord.
And keep it tomorrow. When is the result being
On
declared?
Friday, my lord. Tomorrow, my lord, I'll have it.
কালকে লিস্টে করো shall we or other side and
Grateful, certainly, my lord.
yes, next.
May I mention a matter?
Today is not the mentioning date. Monday and Thursday we
No,
get
my lord,
up
because of the regent, on 9th of October 2023, while Lordship sat with Justice Rai Chattopadhyay, directed the matter to appear before your Lordship in the supplementary list as follows. In presence of both the sides. Since contempt application,
when it was made returnable,
my lord, today it was directed to appear.
was it
And this is the order, my lord.
দিচ্ছ না তোমরা চেক আপ করছো না নাকি জয়ন্ত কোথায়
On that day, Lordship observed that
what is
this
the
matter
problem?
will...
What is the problem, Mr. Bag? Your contempt application will not be proceeded against.
Yes, that's right. On that day, your Lordship held that that order was passed.
So we gave you that protection, and it has been, date has been wrongly incorporated. 11th November was a
Well, that was 19th. Anyhow, my lord,
next week a listed the other way.
on that day, Lordship observed that that was not a regular bench, that was
28 নভেম্বরের লিস্টটাতে দিয়ে দেবে 28 নভেম্বরের উইকটাতে দিয়ে দেবে
well, I'm giving the slip.
What is that? Oh, sleep.
Yes.
Take the sleep.
28th November.
In that week it will appear. We cannot specify the date. You keep a
Well,
watch on the list.
On earlier occasion, Lordship specified the date.
We said 11 November was a
Yes,
wrong
yes, yes.
date. Keep a watch on the list, Mr. Bhatt.
Lordship,
It will
Lordship,
appear.
Lordship.
ওটা দেখে নিয়ে 28 তারিখ ফাইল এসে
Only thing that on earlier occasion,
Yes.
Lordship felt that that was not a regular bench. That's why Lordship deferred the matter after vacation.
My lord, may I?
Giving you the protection.
Lordship.
Giving you the protection that they will not proceed with the.
Yes, yes. 19th has been fixed
Yes,
on
next.
January.
May I be permitted to
Why you are
mention?
mentioning today, sir?
My lord, this matter was supposed to come today. This matter was heard by this honorable bench and order was passed. But in the absence of, as the order was passed, in the absence of respondent authority, later on respondent authority came before your lordship and mentioned the matter. Thereafter, your lordship was pleased to keep this matter today. The order is there, my lord, but
কি হচ্ছে ব্যাপারটা বুঝতে পারছি না।
Yes, my lord, I have checked, my lord.
ওরকম চেকিং
My lord, I have served notice, my lord, to the other side.
কম্বাইন্ড লিস্টটা কোথায়? Have you checked up? It is
Yes,
not there.
yes, my lord.
দেখি লিস্টটা দাও আমার। কি ম্যাটার ওটা স্লিপটা না?
My lord, Jui Final is Private Limited versus State of West Bengal.
Include it in the combined list. Combined list ডিসেম্বরে combined list অ্যাসাইন ম্যাটার হেডে দিয়ে দেবে। Yes, it will appear.
Yes.
আরেকটা চেষ্টা করে দেখি।
Yes, call the list.
My lord, may I bother your lordship for one more time, my lord, for one another matter, my lord?
No, you bother me for the entire day, no problem. Yes, call the list.
And I'm for the petitioner's lordship. This matter, lordship. First of all, I tender apology. Last occasion, lordship, I could not appear. I was engaged in another court, lordship. Today, I'm placing the case, lordship. In a nutshell, the case is the petitioner applied for the post of Assistant Director in the Department of Horticulture, Government of West Bengal. She got selected as par with the notification which is mentioned annexed in page 41. Lordship, kindly come to page 41 once.
Page 41.
Page 41.
Yes.
Now, page 41, my name is appearing in page 43 against column 49, Sudipta Sonnigrai, physically disabled candidate.
Serial 45.
49. The last one, lordship. Physically disabled candidate. Lordship, got it?
$49.
49.
Yeah, just.
43.
So commission recommended your name for appointment.
Yes.
Then
Now, Lordship, I want to indicate two things. Lordship, kindly come to after serial number 49. It will appear from that list that two SC candidates. I'm skipping it. Next paragraph. No candidate could be recommended for appointment to the remaining one post reserved for the persons with disabilities, as the lone candidate belonging to this category was not found suitable at the interview. Next, the appointing authority is requested to verify the following particulars in respect of the recommended candidates before they are offered appointment. 2. The statements of the candidates made in the application regarding date of birth, educational qualification, caste, etc., with reference to the valid original certificates. The caste certificate as per provisions of the West Bengal Scheduled Caste and Scheduled Tribes Identification Act 1994 and West Bengal Commission for Backward Classes Act 1993 and subsequent notification dated 24 September. 3. The persons with disability certificates issued in accordance with the provisions of the West Bengal Persons with Disabilities Reservation of Vacancies in Services and Post Act 1995. So, Lordship, this was the criteria fixed for verification of the date of birth. The credence will be given over the certificate issued by the person with disability certificates. That date of birth would be given credence.
where
Don't you kindly come?
credence will be given, where you are including those words.
This is my interpretation.
What interpretation?
Yes, Lordship, may I come? The statements of the candidates made in the application regarding date of birth, educational qualification, caste, etc., with reference to the valid of the original certificates. The caste certificates as per provisions of the West Bengal such and such, and the persons with disability certificates issued in accordance with the provisions of the persons with disabilities reservations.
So what is your problem now?
Now what has happened, Lordship, I want to indicate another thing of this page. Then, Lordship, police verification is the last paragraph. I am to request the integrity of the candidates who are in the employ of the government of West Bengal may be verified.
Where you are reading?
Last paragraph of page
I am to
43.
request that, yes.
I am to request the integrity of the candidates who are in the employ of the government of West Bengal may be verified by government before he or she are offered appointments. In case the report is in respect of any of them is unsatisfactory, the candidate is considered unsuitable for the appointment, and matter may be referred back to the commission along with the report of the further action. Now, these are the two parts. One is police verification, one is respect of the verifications regarding the date of birth. Next page, Lordship, kindly come. The third line from the bottom. For filling up the vacancies occurring only due to non-joining of the recommended candidates within the period of validity up to 31st July 2022.
Where are you reading?
Next page, Lordship, 44.
Yes.
Third line from the bottom. Lordship, got it? For filling up vacancies occurring only due to non-joining of the recommended candidates within the period of validity up to 31st July 2022. Lordship, kindly mark this date, 31st July 2022. 31/7/2022. Now, Lordship, kindly come to the verification roll. This is my verification roll, 45, page 45 onwards. Page 46, exact date of birth I have given 18/11/1992. On the top, page 46 on the top, 18/11/1992. Now, Lordship, this is the date of birth which is matching with my PH certificate, which is annexed in page.
No, why did you leave out that portion within bracket? Page 46.
Lordship.
So your date of birth is to be supported by birth registration certificate, admit card of West Bengal Board of Secondary Education or any other recognized board.
Lordship, to be supported by birth registration certificate or
Hmm.
admit card of West Bengal Board of Secondary
Hmm.
Education. I have given my birth registration certificate, which is annexed. Lordship, kindly come to
51.
page 50 and 51. 50 is the original given in 1992.
50 is the- Your West Bengal Board of Secondary Education birth is
Yes, there was a
86, first day of April 1986.
that was a wrong entry. Now I'll come to that this date is not affecting the service also.
How do you wriggle out yourself from the certificate?
Yes, Lordship. Welcome.
Today we are in 2023. You appeared in the exam.
My
in
birth
20
certificate says
Forget
1992.
about birth certificate.
My-
Why didn't you take steps for rectification of this date of birth?
No, Lordship, that comes later, Lordship. My argument is something else, Lordship. May I place my argument, Lordship? It's this.
কোন দিক দিয়ে আর বেরোবে?
No, that is at the time. Now, which document would be given for credence over what?
You tell us which document is given. There are
My PH
numerous
certificate
judgments.
is there. My PH certificate is there. My birth certificate is
Your
there.
birth certificate, your date of birth will be
My affidavit is there.
as incorporated in your recognized board certificate.
No.
That is the first preference. If that is not there, then comes other ancillary documents.
Now, Lordship, now whether this is to be verified by the police, and that too after expiry of
Suppose-
9 months.
Suppose there is no verification. Suppose we are verified. What will be your defense, sir?
Now, difference is that, Lordship,
Tribunal has
this
passed a right
age is
order.
not affecting anything, because if my birth year is considered to be 86 also, I am falling within the zone of consideration,
How?
because it is the 36 years is the age limit maximum for inclusion in the service. Lordship, kindly come to page 33. Page 33. Lordship, the last line of this column, age not more than 36 years as on 1st January 2020.
37 years.
36 years, Lordship.
37, page 33.
Yes, Lordship, the first column,
First-
Assistant Director of the Horticulture.
Hmm.
The last column, age not more than 36 years.
Where you are getting 36? It is 37 here. Oh,
Lordship, Lordship, the first
you are for Assistant Director Horticulture.
36. Now, Lordship, kindly calculate from 86. If my age is to be considered from 86, then it is falling with the zone, within the zone.
1st April 86.
96, 2000,
2016.
33 years. And 92, obviously, I'm falling within this.
So your contention is even if the birth certificate, board certificate is accepted, you
Yes.
come within the zone of
Zone.
consideration.
Now, Lordship, I know the difficulty which I am to face. That is the difficulty of that which credence will be given, whether I have taken any step to correct that document. Now, Lordship, if I could not, Lordship, I could not take any step regarding this document. By this time, it's an admitted position.
Show us the tribunal order. What
Yes,
did the
Lordship,
tribunal-
kindly come to tribunal order. Lordship, kindly come to page 62. The matter is taken up for single bench. I'm skipping it. The applicant has prayed for a direction to the respondent authority to submit police verification report of the
Where
applicant.
you are reading, Mr.
Lordship, kindly come to page 62.
62.
Yes, ma'am.
Order.
Yes.
Yes. Which paragraph you are?
Third paragraph. The applicant has prayed for the direction to the respondent authority to submit the police verification report of the applicant to the department of such and such. It appears that the applicant participated in the recruitment test conducted by the Public Service Commission for the post of Assistant Director Horticulture. The candidate belongs to the reserved category, physically disabled. The commission subsequently finalized a list of recommended candidates and furnished the same before the respondent department. the complete formalities, her dossier were sent to the police verification. During the inquiry, it was found that the applicant had two different dates of births in two different documents. In her birth certificate issued by the sub-register birth and date Simlipal, such and such, the date of birth is shown as 1811 to 1992. In another birth certificate issued as form number 9, designation of the authority is not legible. The date of birth is shown as 18/11/1992. The certificate was registered on 20/11/1992 and the issuing authority signed this on 8/1/1993. These dates differs with the dates recorded in the admit card issued by the West Bengal Board of Secondary Education, in which her date of birth is shown as 1/4/1986. The admit card relates to her appearing in Madhyamik Parikha of 2006. To clarify such discrepancy, in the dates of birth, the respondent authority had asked applicant to appear with relevant documents, but it appears from page 52 that the applicant did not appear on the date from the above facts. It is the observation of the tribunal that the applicant has failed to appear as informed before the deputy secretary, and that too was after the expiry of that 31st July. Clarify that the doubt regarding her date of birth.
That you did not argue that if 86 date of birth is taken, you come within the zone of consideration. That was not your argument before the tribunal.
No, Lordship, even that.
Your tribunal argument was that there may be mistakes. For that police verification, it should not be sent. Even if I have not admitted, in this case, you are saying even if I have not applied for rectification, treat my date of birth as 1st April 86. Then also I come within the zone. Where do you have argued that?
Now that even the affidavit was not called for.
So maybe you must have taken a ground to that effect. Have you taken any ground to that effect?
No. If this is Lordship an argument, Lordship, which should have been made. Now, Lordship, your
Where
Lordship
is
has
your ground in this petition that is a valid? This was the step taken by you.
Lordship, which step, Lordship?
Who appears for commission? Have you served commission?
Commission, Lordship, has been served.
Where is your affidavit of service?
এটা কোথায়? এটা কোথায়? দেখে নাও তো কত নম্বর?
That is nowhere in your petition. This is a new argument you are making. তাই না?
Commission is served. Lordship, commission is served, Lordship.
Genuine, ওইটার basis এ তুমি disqualify. কি বলেছো?
ওই এটা তো কেন নেই? Lordship, commission is served.
Now, where is that ground, Mr. Chatterjee?
But the original way is not been annexed.
Point ধরেছে, ওই annex করো।
Lordship,
Show us that ground you argued before the tribunal. How
Lordship,
can
that was possibly not argued. I will not.
then go before
hide
the
anything.
regular? এই আমাদের কি WPST determination আছে নাকি? WPS, হ্যাঁ? তো দেবাংশুর আছে তো? না না, দেবাংশুর ডিটারমিনেশনটা দিয়েছে আমাদের। তো দেবাংশুর ডিটারমিনেশনে WPST ছিল তো?
Yes. That's it.
এখন দেখি কি করে বুঝবো?
হ্যাঁ, এটা 4 তারিখ অব্দি মঞ্চের বাইরে বলে বেঞ্চটা এনাকে দেওয়া হয়েছে।
তুমি শিওর? Come with a supplementary evidence.
Documentary affidavit, I will disclose the way and Lordship.
Bad case, bad case,
Lordship.
bad case.
Lordship, only thing is that your Lordship has the power, Lordship, under Article
You have the power to make new arguments. We don't have the power to deal with the same. We deal with this.
Great.
Also, the learned advocate appearing for the Mr. Chatterjee. Learned advocate appearing for the petition. This will leave to file a supplementary. Let a supplementary affidavit be filed within a week from date with a copy to Mr. Mukherjee, learned AGP, appearing for the state. Opore evidence of service filed by the petition kept on record for the establish the matter for further consideration in the daily supplementary list of this case. on 11th December. Stop. Mr. Mukherjee is also directed. Mr. Mukherjee is directed to avail all necessary instruction in the meantime. You within a week you give a
Matter
copy.
will appear before this bench, Your Worship.
11ই
We have
ডিসেম্বর
set 11th January.
Lordship.
Determination shows we have. If determination goes to that, it will go
Affidavit of service we kept to them.
11th December.
Grateful, man.
হ্যাঁ চলে এসেছে
But
In this matter, I am the petitioner.
Twenty-one.
Yes,
But in this matter, I am for the petitioner. I am for the petitioner, my lord. But this application is to expedite an order of interim order was passed by learned tribunal on 5/8/2021, my lord. In regard to an application which was filed by the apparent opposite party, challenging the seniority list issued by the petitioner, my lord. Now, interim order was passed on 5/8/2021, my lord. Thereafter, my lord, matter is pending till date, and an application for vacating the interim order was made before the learned tribunal. That is page annexure P5, page 45, my lord. Because, my lord, by virtue of this interim order, the promotional scope,
when did you file this application?
this is in file on 11/10/2021.
Now, what happened on 23rd August 21?
My lord, in all, there are total 22 adjournments are given, my lord.
Show us that.
My lord, starting from page 55, my lord.
Page?
Page 55. First of all, my lord, landed.
Page 55.
Yes, my lord.
Yes.
Mr. You're for whom?
I'm for the respondent number 21. Private respondent.
Private there are
The
only
stage,
you are for 21.
only 21.
What about the others? You have served.
Yes, my lord. When he's
With respect to the original applicants, my lord, I beg to refer.
there are added
Who are they?
respondents and original applicants. My lord.
I'm not for the added response.
No, you are for the original applicants. Original
Mr.
respondents.
Dotto, you are appearing for 21.
21.
And for the other respondents, you are appearing.
My lord, I'm appearing for the original applicants who are, my lord, respondent number 190.
Other respondents are also my clients, but they could not give me Vokalatama because,
Oh, you are appearing for all then.
but they could not give me Vokalatama because they are at their native place for Chhat Puja. And
But the matter is only to expedite because, my lord, it will either because of this interim order, my lord, the
When
entire.
did you vacating application? When did you mention before the tribunal?
Yes, my lord, it is there.
Where it is there? That your mentioning was refused, etc.
actually,
My lord, on
Mr.
31/8/2021, my lord, there is there Mr. S.K. Dotto, London Council filed an being MA for 415/2021 for adding as a party respondent is allowed. Therefore, MA 415/2021 is allowed.
So, Mr. Dotto, you avail that Vokalatnama. Otherwise, we have to deal with in that. We cannot record your appearance for that.
no, 21 I have the Vokalatama. For 21 I have the Vokalatama.
No, for the others.
Others, my lord,
Where
actually,
is the service upon others? Show us.
My lord, we have served the for the added respondent, the first added respondent and added advocate one appearing on behalf.
And you will leave out the other applicants. Complete service and come. How can we take up without
But
service?
because my lord,
we are also interested. Mr. Chakraborty is appearing for the applicants before the tribunal. He also mentioned that
Who?
Mr. Ashok Chakraborty
Uh,
is appearing for the applicants there before the Honorable Learned Tribunal. He also mentioned, I mentioned, everybody mentioned, but Learned Tribunal.
my lord,
is
matter has been
not
dragged for a
taking
long
up.
time, my lord. Only
Yes.
prayer is my lord to expedite the my lord, because interim order is granted. Either the petitioner will win or the respondent will win. That is defined as well, my lord. But only until a hearing is concluded, my lord, entire thing has stopped, my lord. Only that, for that reason, we are not challenging challenging the order. We are only to expedite the hearing process.
Tomorrow is the date fixed before the learned tribunal, but most probably it cannot be taken up. Bench is
Mention before the tribunal tomorrow.
But my lord, the bench is not bench to me.
bench is available. One of the learned members is sitting virtually, but the soft copy has not been sent to him. So
Mention and come back next Monday, check up your service. Eight the other.
Monday probably
Next
or
Tuesday.
Tuesday.
Next Tuesday, or we give you Tuesday week. Try your luck there. Otherwise, complete service and tell us. কি করবেন বলুন তো, এক একটা মামলা 2 বছর 3 বছর করে মামলা ফেলে। It will appear on
My lord, if you
5th
also kindly pass
December.
an, my lord, if you also kindly pass an order, my lord.
That will create problem for you. We
Because
are
otherwise,
keeping
my
it
lord,
on 5th. You come with the adjournment dates, we pass necessary order and tell Mr. Chakraborty to appear. Then your service will also be complete. Take necessary steps. Yes, next.
My lord, three, I beg to appear on behalf of the petitioner, my lord. My affidavit of service.
Who is your other side?
Serve all of them, my lord. Service is affected, my lord. The service have been affected. I have given the affidavit of service.
Yes, tell us what is the matter.
My lord, challenging the order of the Kolkata
Mr.
bench of Central Administrative Tribunal.
Who appears for Union of India? Who has been engaged? Have you ascertained?
It has not been ascertained.
Please ascertain and come back. Make us service. Yes. Moreover, regularization.
Yes, my lord.
You ascertain who is there, bring him. Not this week. Yes.
My lord, can it be on 28th? On 28th.
Not this week.
Keep your list.
Study cricket.
Mr. Urjun Rai Mukherjee appearing on behalf of the applicant. He is engaged in another court. He was over here in a short person.
You are there for the respondent. Who is for the respondent?
I have served.
Not today. Yes, next.
But I am for
the respondent.
well, this is the affidavit of service. A very small case. But I have filed a case before the tribunal only seeking for a direction. Order of the appellate authority has to be complied with by the BLR. Nothing else. Your lordship will see the order of the appellate authority. Appellate authority has set aside the order of the BLR and directed within 5 days you correct it. And my land is a VT. It was interpolated by the BLRO recording the Khelar Mart. But I prefer an appeal. Appeal court set aside that and directed immediately you correct it. How it is interpolated?
How you are for the private respondent?
No, my lord. I am for the
I have served, my lord, they have received. Only your lordship kindly see the page.
You are for whom?
for state, my lord.
Have you served upon this respondent number 4?
Yes, yes, yes.
Where is
Everybody is taken. Delivery
it? Check
confirm.
up, sir. Delivered or not?
Delivery confirm.
দেখে নাও।
Delivery confirm. All delivery confirm.
My lord, petitioner's prayer is only expeditious hearing before tribunal.
Why tribunal is not sitting regularly?
Yes. Your lordship
Then,
kindly see
when was the DLRO order passed?
43. Your lordship kindly see the page 43.
Page
That is 2022.
43.
Yes. Last line kindly see 43.
On being mentioned, matter is taken up. Council are present.
That is the
Submitted
tribunal
matter
order.
is as item 27.
That was fixed on April.
There is another way.
Maharaj,
Crossway.
no, that is another way. I have filed previously when the BLRO has not been taken. That was disposed of.
How can that be? Because the OA number is of 2022.
Is a cross matter.
This OA is also 2022.
Maharaj, page, first of all, your lordship, page 32. Page
So
32.
it was directed to appear on 1st April 2024.
Yes. 1st April 2020, when the DLRO has said, appellate authority said within 5 days you correct it.
Where is the appellate authority order?
Maharaj, page 32.
Page 32,
Yes, Maharaj.
24 January 2022.
Page 32. Yes, yes. Yes, Maharaj. Last paragraph, kindly see. Set aside the order and directed within 5 days you correct it.
You
My
read-
VT.
You can read the order.
Yes.
You can read the order. We
Yes,
cannot
yes.
read the order.
Hence, after considering the document on record, it is hereby ordered that the instant appeal be and the same is allowed. The concerned BLRO is directed
Hmm.
to restore the classification against the riot under the plot number such and such. The
Block.
plot.
Block Kalna such and such.
VT. Now this was recorded as VT
The compliance of the order
within 5 days.
is to be within 5.
So why you are not doing it, sir? What is your problem in not doing this?
My lord, in that case, my lord, I have to take instruction, my lord, but
We will ask your BLRO to be here.
My
Ask
lord-
your BLRO to be in court.
my lord,
What is this going on? Your superior officer says
Yes,
that do it within 5 days, and you do not do it.
my lord,
Man approaches the tribunal. Tribunal bench is not taking up. So where will he go?
my lord,
Have
Pro-
this order been challenged by you?
no, my lord.
You are
Actually,
for
probably-
BLRO.
No, my lord. For state, my lord. My
So
lord,
state
for
includes
BLR,
BLRO.
BLR.
Yeah.
My lord, kindly see, my lord, probably there is a cross order, my lord. I could not take
Pardon,
instruction.
pardon.
Probably there is some cross matter, my lord, because, my lord, kindly come to page number 43, my lord. 40 is,
This OA, Mr. Arifin, tell us properly whether
lord,
this OA
this is submitted-
728 is an
is a cross matter, it is written, my lord.
728 has been filed by you or by the private respondent, challenging the order of the DLRO.
My matter is below OA number 3164 of
সে তো
2020.
আমরাও দেখছি what is this, why the tribunal will say cross matter? Where is this OA 728?
This instruction not with me.
সাতকাণ্ড রামায়ণ পাঠ করে?
No, my lord. But I have only seen the order of the DLRO. DLRO has directed within 5 days you do it, whatever it may be. Cross, he has to taken up this matter within a time of a very short period.
Where is your OA? You have annexed your OA?
No, my lord. Subsequently, I have received it. This is the way, my lord, I must apply. This is my way.
Wait, okay. You preferred the application. What is your prayer? Implementation of BLR order?
Yes, 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 only.
This is এই দেখো 728. You have the record, you say you do not know. 728 cross matter has been filed challenging the BLR order.
ওহো, আমি সেটাই দিয়েছি।
কি বলছো আমি জানি না।
I have given it.
Mr. Reader,
এইটা আমারটা।
is there any injunction in that matter?
No, my lord.
Then why your BLRO is not doing so? There is no order upon you that do not act in terms of DLRO.
My lord, kindly give us, my lord, 7 days time, my lord. Let me take instruction properly, because, my lord, day before yesterday, you have been briefed, my lord.
Affidavit of service filed by the petitioner be kept on record. Stop. In spite of service, no one appears today on behalf of the respondent number 4. ও আছে? Yes, you are there. You are there.
For the state, my lord.
To solve the
The state.
problem, Mr. Ganguly, DLRO said do it within 5 days. You have kept it for 5 years. কি বলেছো? No one appears on, though Mr. Ganguly, learned advocate appearing for the state respondents is present. Stop. Third, Mr. Arifin, learned advocate appearing for the petitioner. He alleges
সেটা পেন্ডিং
no, Mr. Arifin, learned advocate appearing for the petitioner submits that the petitioner was constrained to approach the learned tribunal for implementation of the order dated 24th January 2022. Huh? Passed by the respondent number 2, drawing our attention to the said order. He submits that the respondent number 3 was directed to restore the classification against each riot under plot numbers 416, 417 and 418 of Block Kalna Roman 2, jail number 2142, quote unquote VT. It was further directed that compliance of the said order should be done within 5 days, from the date of receipt of the order. Stop. In spite of such specific direction, no steps were taken by the respondent number 3, and as such, the petitioner was again constrained to approach the learned tribunal. However, the original application referred by the petitioner in the year 2022 is pending till date, and the next date of hearing has been fixed on 1st of April 2024. Stop. Mr. Arifin further submits that the order of the respondent number 2 has not been stayed, and that as such there is no impediment on the part of the respondent number 3 to immediately comply with this.
Yes.
Stop. Records reveal. Next paragraph. From the order passed by the learned tribunal, stop. Mr. Ganguly, learned advocate appearing. Mr. Ganguly, learned advocate appearing for the respondent for the state respondent, including the respondent number 3, is directed to avail necessary instruction as to why the order of the respondent number 2, which was asked to be complied with within 5 days, has not been complied by the respondent number 3 till date. In the come with that instruction, and whether there is any stay order in the original application.
Yes.
That you cannot say.
Well,
Is there any order?
I shall take a step.
No, if there is an order of stay, then our record,
No order of stay is there.
where you have written that in
No,
your
not-
application.
Not written below, I shall.
No, তাহলে এত order pass করবো কেন?
But my landed friend is also there, he is moved.
But he is
For the high.
he is assisting me.
He is appearing with him. Is there any statement you have made that there is no?
I have not made.
Then how can we pass the order?
But there is no stay order below. When I
Well,
passed-
actually, cross matter has not been pleaded over here. That is the difficulty. So let us ascertain if entirety, my lord, we will come back as your lordship pleases, my lord.
কেটে দাও, শুধু লেখো affidavit of service filed by the petitioner be kept on record. In spite of service, no one appears today on behalf of the private respondent number একটু দেখো তো প্রাইভেট রেস্টুরেন্ট দেখে নি।
নাম্বারটা কত আছে?
Yeah, appear করে।
Petition আছে।
Service,
সেটা বলেনি ওই ইয়েতে আছে।
and all service confirm.
প্রাইভেট রেসপন্ডে তার আগেরটা প্রাইভেট রেসপন্ডেন্ট নাম্বার 4।
Five. Five.
হ্যাঁ?
Five.
এই তো সেক্রেটারি, ও তো প্রোফর্মা ফাইল।
Five.
ওই আরেকটা অ্যাপ্লিকেশন দিয়েছিল, হু হ্যাজ ফাইল দ্যাট শো দ্যাট হু হ্যাজ ফাইল, হ্যাঁ এটা কে ফাইল?
Well, in any event, as Lordship, my lord has already directed that to take instructions as to why steps has not been taken. We'll have to explain why we have not taken the instruction if there be any.
Mr. Ganguly, apply your good office. If there is no stay,
My lord,
why your
we will,
PLR
we will, definitely, my lord, as it has
Despite the
fallen from your
service, no
Lordship,
one
my lord.
appears on behalf of the private respondents. Stop. Third, Mr. Radefi, learned advocate appearing for the petitioner. Mr. Ganguly, learned advocate appearing for the state, prays for an accommodation to avail necessary instruction. Stop. Please the matter for further consideration in the daily supplementary list of this court on 5th December.
5th December.
You come with that instruction.
My lord.
Yes.
With the entirety of the whatever has happened, my lord.
If there is no stay order, then ওনাকে ফেরত দিও।
It's for expeditious hearing of the tribunal application which is pending since 2021. There is a subsisting order of injunction in my favor before the tribunal. But if your lordship, I have annexed, there are three analogous matter, arising out of three mutation case.
Well, I'm for the private respondent. Well, I'm supporting the cause, my lord. It should be, my lord, directed, my lord, to be
Why
And
Mr.
once, 1 day in a year, I
Yes.
get 1 day in a year. That is the regular practice. But how that day is being utilized, kindly see. On the day, the matter when everything is ready, adjourn for thrice. Thereafter, the learned judges is of the view that LCR should be lower court record. Your lordship knows the mutation case, whatever document we both are relied upon, that has been annexed in the original application
Yes.
itself.
It's a voluminous petition, my lord. All documents have been annexed. Well, I
There is no
support.
need, for the
Then how can we help? If the tribunal says I will consider
My
the
lord,
records,
my lord, subject to lord's kind consideration, my lord. The next date fixed, my lord, in the month of February, my lord. On that date, it's my lord, kindly fix, my lord, for disposal.
12th of
Right, sir.
February, yes. 12th of February 2024 is the next day.
On that date, my lord, positively, my lord, it should be disposed of. All three petition, my lord, should be disposed
you
of.
are appearing for whom?
Private respondents, my lord. In fact, my lord, I'm suffering by an interim order.
Because initially my name was being mutated, thereafter they applied for recording their name in respect of 17 decimals of lakh. In a particular plot. That was being done. Thereafter, I preferred an appeal before the DLLRO. That order was being affirmed, and thereafter the three consecutive petition before the Land Reforms and Tenancy Tribunal.
But this is in connection with one original application.
No,
My lord,
three.
in the prayer, my lord, there are, my lord, mentioning of two other matters.
And
There
it
is
takes
a
up
technical
the
difficulty.
preamble. Page 1 of my application, your lordship will get the three numbers is being mentioned. It's analogous matter, arising out of
Same party,
same parties,
No,
different plots.
different plots.
same, my lord, I'm appearing, my lord, for all the in the private respondent, my lord. Other two matters, my lord, although my lord respondent are different, my lord, but my lord may pass the order, my lord. There's a difficulty, my lord, on consent. Other two matters, my lord, two other private respondent, different private respondent there.
You are enjoying an interim order.
But
What is your problem?
But his name is being recorded.
So what?
That is my lord.
That they will not take.
Well, that is my lord. That is why, my lord, I'm consenting, my lord.
Request করছি, অমুক করছি, তমুক করছি। So, Mr. Mujhe, try your luck on 2nd of April,
12th of February.
12th of February.
But,
Then come to us.
Previously also, the matter was being adjourned. Previous orders I have annexed before your lord.
April 23, my lord, it was taken up after a year, 1 year, my lord.
14th of September 2021, the interim order was being passed.
14th of
September 2021.
Have you annexed that order?
Yes, I have annexed. The bunch of certified copies, your lordship will get the 14th September 2021 order. Has your lordship got it? My lord?
That is only in respect of one.
My lord, no, no, my lord, 3 orders I have annexed. My lord, I am not disturbing your lordship regarding the other 2 similar order. My lord, your lordship can, my lord, look into.
And strictly speaking, there ought to have been 3 applications here. Different matters have been passed. Where is the order of analogous hearing? Is there any order of
No, my lord,
analogous
one
hearing?
after another, my lord, on the same day these 3 matters was being kept, my lord, in the
But
cause
how
list.
can we exercise jurisdiction in respect of the others which are not here? We don't know who are the parties.
Your
We
lordship,
don't know who are the parties.
but your lordship knows, my lord, regarding the expeditious hearing, your lordship's court
So
is of the
that
view
becomes a
that since it's an
procedural
order,
defect, no?
since it's an order, my lord, not prejudicing, my lord, anybody, my lord, your lordship passes an order, my lord, even in absence of the other side also.
In fact, my lord, on that day,
14th of September, what happened?
My lord, 14th of September, the initial, my lord, interim order was being passed.
Where is the
My
interim?
lord, kindly takes up, my lord, the second page of the order.
Not to create any third
Yes,
party.
yes. And thereafter, kindly takes up, my lord, the next onwards order. 4th of May 2022, your lordship kindly see.
No, no, there was another order of 5th December. 4th of May.
4th of May, my lord, thereafter. Learned advocate such and such, my lord, for the applicant, none appeared on behalf of the private respondent. Learned advocate of government representative is present. Files, photostat, copy of the appeal case number such and such is kept with the record. Let the matter be appeared in the list for hearing on 5th of December 2022. Kindly see, my lord, the 5th December order.
The court was not sitting.
Today matter is appeared in the list under the heading hearing, but the honorable administrative member is on leave and the substituted bench is functioning. In such
11th
circumstances,
April 2023.
now 11th April 2023 for the hearing. Kindly takes up, my lord, the 11th April order. Now, at this stage, learned government representative prays for extension of time to produce the lower court record. Lord, this kind of appeal, my lord, your lordship knows it's.
No, no, our knowing will not help. Your counsel did not oppose this. So many things were not said before the tribunal. 11th of April, their prayer, you allowed them to take in young.
But I am not on that also, my lord. Now, my lord, the time was being
11th
short for.
April.
Now, my lord, the time was being short for. My lord, once in a year, I get the opportunity. Next date is being fixed on 12th of February 2024. On that day, the my lord, government representative ought to have been, my lord, will present, my lord, the LCR. Let on that day, my lord, the matter be heard. My lord, I want that order only. I am not challenging because as on today, my lord, this was passed in April 2023. Got 1 year of time to produce LCR. Now, February is the date fixed in the next year. I only want, my lord, that innocuous time, my lord, so that, my lord, on that day, my lord, the matter can be heard out.
আমরা অর্ডার করে সেদিন কেউ আরেকটা Have you filed any vacating interim order application?
Not yet, my lord. My lord, I cannot open my mouth, my lord. I was not represented, my lord, on the date, my lord, that my land will mention, my lord. But still, my lord, I support the cause of my lord. Petition, my lord.
Otherwise,
Let that be, my lord, on the fixed, my lord, date, next date, my lord. On that date, my lord, all the application, my lord.
the original application are otherwise ready for hearing. Your lordship has
Where
seen,
is
my lord.
that?
Yes,
Your
my lord,
reply
it was
rejoined-
kept for hearing.
Where?
My lord, by the last, my lord, 3 orders I have shown before your lordship. Let the matter appear in the list on 12th of February 2024 under the heading hearing. So it's, my lord, the matter is kept, my lord, under the heading hearing. Even previous order also shows that.
And my lord, there is, my lord.
Mr. Mukherjee, what is the procedure? Suppose the court does not prepone. You have to make an application. You are favored by the tribunal with an interim order. As a stopgap arrangement, you come and tell us.
No, my lord,
Today,
it's-
what we will say, suppose.
I got an interim order in 2021.
Very
Thereafter,
good,
my lord, the
your-
matter is ready for hearing. I only, my lord, request your lordship so that your
You
lordship can
request
pass.
the tribunal.
Lord, your-
Why you are requesting us? It is before the tribunal you request.
Lord, your lordship knows, my lord, when the suit is being pending, we approach the revisional court who is exercising supervisory jurisdiction. And now after, my lord, this
That is in, you are enjoying an interim order and you are coming and saying that give us immediately hear out the matter.
Lord,
And
it's-
they do not have filed any application for vacating
Lord,
interim order.
they did not because they
So
are
what is
contesting the original
what is
application.
your grievance? What difficulty you are facing?
Look, from 2021 till date, though the
You are
matter is
enjoying
ready for
interim-
hearing,
You are
Lord,
enjoying the
it's
interim
not only, my lord, the interim order. Lord, my name is being struck off in respect of a land where, Lord, I do have my purchase deed. Lord, I want, Lord, that remedy to be availed of. Whether my name, Lord, striking out my name was proper or not, that has to be adjudicated by the tribunal. The matter is otherwise, Lord, ready. And if again, my lord, this one pretext or the other, my lord, the matter is get adjourned, my lord, again I will have to wait for another year. That innocuous prayer, my lord, before your lordship.
My lord, it is not required to be lordship.
No, I am not seeking for preponement.
No preponement, my lord. On the date fixed, my lord, those three applications, my lord, may be, my lord, taken up.
Okay, I will dispose of for you. Because you are waste. Nothing, 12 तारीख को fine. You have served upon the state.
Lord, the affidavit of service is not ready. If your lordship, Lord, since it's a expeditious hearing, madam, Lord, I have served to all.
You have not served upon, you are appearing for whom?
Respondent number 4.
Respondent number 4. Who are the other persons?
No, others, Lord, are the state respondent, district land and land reforms officer, block land and land reforms
Have you
officer.
served? Complete service and come.
Since it's an expeditious hearing, Lord, your lordship.
No, everything cannot be so casual. Everything cannot be so casual. Mr. Mukherjee, learned advocate appearing for the petitioner, submits that service upon the state respondents is not complete. Is the matter for further consideration on 6th of December. The petitioner is directed to complete service in the meantime. Yes.
Grateful.
Mr. Mukherjee, please check up. You are now quite senior. This creates an impression that you can do away with the procedural law what is laid down. Only expeditious hearing kindly. High Court is not a post office. Once we exercise direction, it is our duty to implement our order.
Oh, Lord, it's civil revisional matters. Your lordship knows, Lord,
This is-
expeditious hearing, we should not serve, Lord. And the
Is
day,
it a civil revision matter?
that's why, Lord,
You are questioning the court. You are saying that civil revision can be
Lord,
done.
the
Why
affidavit,
this court
Lord,
will not?
everybody was being sent, Lord, but the affidavit service is not ready, Lord. I must be candid before your lordship. That's why.
Everything
come back to
cannot
that.
be so casual. Otherwise, all the appellate side rules and everything has to be thrown out. One cannot be so casual. Yes,
Great.
next.
This is a Group 6 mandamus appeal.
Is appearing for final hearing.
No, it's a first application, stay application. The issue pertains to pay fixation in short. That he had served his tenure in our office after being reinstated in service by an award of an industrial tribunal modified by the division bench to the extent of not granting him any benefit during the period of back wages, except for allowing him to resume duties in an appropriate post with pay. So no benefit of back wages in the interregnum. That was the modification made to the award by the Honorable Division Bench in respect of an industrial tribunal's award.
Wrong interpretation of the division.
I shall show to you. Be that as it
I
may,
cannot interrupt him.
Your service is complete,
but he is
Mr.
appearing in person.
I am appearing in person, my lord.
Who is this director in charge of Webel
No, no,
State?
our
Sir, direction has been made, my lord. Chairman and managing director of the WBIDC, appellant.
not the
Single bench order has been made.
company got merged
When
with
the court asks you, then you will open your mouth.
Okay.
You take your seat there.
Okay, sorry.
but the company suffering the award got merged with WBIDCL, therefore not it got substituted.
No, you are for West Bengal Electronics Industrial Development Corporation. Now, this director in charge of Webel Electro Optics is what?
Not
Was a
this,
subsidiary.
yes, it was once a company which got merged with this WBIDC. The
Oh, I
cause
see.
title had to be made appropriately. That's why this.
And why the state is a party?
No, in the writ petition, state was a party.
You have served them?
Yes, it's there.
Yes, tell us.
Now, after being reinstated in service by reason of the fresh appointment order in 2017, the company got merged in 2019 with WBIDCL, Electronics Industry Development Corporation Limited. Webel Electro Optics got merged with WBIDCL. Now, he served this company and superannuated in 2021.
No,
Yeah.
when was the merger?
2019.
Webel merged with this company.
Webel Electro got merged with WBIDCL.
That is appellant number.
Apparent now.
Yes. Now what happened?
Now question arises with regard to implementation of ROPA 2009 in respect of the earlier company, the merged company, vis-a-vis the company which has now taken over the merged company. Now, for this purpose, your lordship may have to look into not the order of the Honorable Division Bench which modified the award once. This is at page 101. What was the?
What is the interim order scope?
And the direction is of twofold. Number one, it has directed him to be placed at a higher stage of the pay band by treating him, not we placed him at the lowest stage of the pay band 3 with a grade pay of 3,900 for which he was drawing a pay of 42,000 and odd on the date of his superannuation. By reason of the order passed by the Honorable Single Judge, he has been asked to be paid a higher incremental stage for which there will be certain additional financial liabilities on us. This has been directed to be computed and disbursed to him by treating him at par with another employee who had superannuated long before his superannuation.
So the other employee was similarly situated.
Now
with
that's
him?
the point. Not where he was to be put. Where
Now,
he was to
any
be put.
contempt application preferred?
Not he filed a contempt application. We received a contempt notice. Whereafter, not we mentioned this matter before your lordship last week probably. After that, we received
All
a
the records, all the documents are on record.
we received a contempt notice, not a contempt application. Supplementary affidavit, yes, not opposition and the not all necessary documents are there. Apart from that application for substitution, all these things we are.
Then we fix a date for hearing.
To put it in one sentence, it's a case of fitment under ROPA 2009.
সময় লাগবে তো। সেটাই তো। আপনার সাথে শুনে নেবো তারপর ফিক্স, তাহলে শুনে শেষ করে দিতে হবে। সম্ভব নাকি? Just show us the order imprint first. and
It begins
let
at
us-
259. The relevant portion would be at
When did he retire?
2021.
When-
October 2021.
Achha.
4th of October 2021. He has got his dues, not according to us, not whatever is table, he has got his dues. But it begins at 259. The relevant portion would be at 264. That's the internal page.
Have you checked up all the record? All the documents are on record.
My lord, I am sorry that I have interrupted you. It is not my intention to interrupt you. I respect. Records, they have all submitted. Adopting unfair means and with a malicious motive, few records has not been placed here.
Those were there before the read court.
Yes, I can show you. This is on record. And the single judge, Honorable Justice Lapita Banerjee, has incorporated in the order with a malicious motive they have not filed. If you allow me, I can file this.
Which document?
This will be just a minute. Just a minute, my lord. Just a minute, my lord. Order this thing.
Mr. Pal.
Yes, sir.
Whichever documents were there before the read court.
Yes, sir. Yes, my lord. Read code is there. I am reading out the judgment.
We are asking a simple question.
That has been submitted by in the read court.
That has been.
Yes.
That those are their documents or your documents?
Appellant documents, not my documents.
So you give those document copy to your friend, he will file a supplement.
It is the appellant documents, my lord. It is not the respondent documents.
Yes, Mr. Mojumdar.
Read petition, opposition, reply to
This
supplementary affidavits. These are all there.
Then you will compare with that.
If the court has taken into consideration some.
I am showing reading the judgment.
Our leadership wanted a chart to be prepared. That separate
With
chart
the
was not
malicious motive, they are not submitted.
Wait,
please.
Chart to be prepared
for the purpose of appreciation of the factual matrix. Those were filed in court for the purpose of assistance of our leadership. That was not, of course, part of the record. If your lordship may call for, this will be a part of the
My
record.
lord.
But these were not through affidavits.
This record they have submitted on 3rd August. Why they have not submitted?
make an informal copy and give a copy.
To hide, to conceal the matter. Total documents they have not filed.
Wait, we have told him.
And this is the thing, it is incorporated into the judgment, my lord. This is not
When can you do
intentionally
it?
they have not filed. My lord, I am requesting.
When can you do it?
And we can do it in 1 week's time. 1 week's time.
My lord, I am requesting you, please, my begging your pardon, begging your appeal. Will you kindly accept, my lord?
They will bring. We have told them they will bring these copies.
So the RTI reply, I have made the RTI, my lord. Why I am so much agree.
Wait.
RTI and whatever the retiral benefits as per direction of the Honorable Justice Arindam Mukherjee without prejudice to the rights and contention in the writ petition which they have paid. That will be more helpful for you to take the decision.
They will come with that. Don't worry.
And why I am telling you, my
come
lord.
On 6th. Come on 6th of December. They will come with the documents and we will finish it off. Yes. Next.
My lord, one appeal, my lord. I have retired on October 21. And I am not telling you single quote at this thing. If you kindly that you are giving the stay, they are telling the
No stay granted. We have told him.
Because
that
October
the
21, I have retired. And I am harassing, this intention is lengthening the.
We have not granted any stay. We
Okay.
will finish off the matter on 6th, on which day he will bring the documents. Understood?
Yes.
Very good.
But they have
Come,
to find, they have to submit these documents.
that we will check up. Leave that
okay.
upon us.
Okay.
Yes,
Okay.
next, Mr. Mojumdar, make a.
They have alleged you.
Again, you are.
No. Why I am telling you, my lord.
Whatever chart, whatever we have prepared, we shall bring it.
Please make it so that he.
Whatever filed before that single court that is to be submitted.
Yes.
They are trying to conceal.
Yes, next matter.
My lord, he is making the charge that the 13th,
Very talkative it
no,
seems.
13th
You are very
September, they are
talkative.
filed, they are sleeping.
We are keeping it on 6th. If
Okay.
they are, we will ascertain that and we will pass necessary order.
Okay, my lord, thank you. Thank you, I'm grateful.
Yes.
Don't take it otherwise, please kindly realize my agony.
Yes, next.
My lord, item number 8, my lord, I'm led by Mr. Shubhankar Nag. My lord, he's on his legs, my lord. Will it be your lordship's pleasure to, my lord, grant a short passover, my lord?
দাঁড়াও, 1 minute. Lord, I think, my lord, that there is an official note in the file.
Out of time.
That out of time. Therefore, we have to file an application under section 5. Otherwise, we cannot open
Yeah,
my mouth.
moreover, this is not our determination. Go to justice.
Yes, that is, we shall go to there.
Mr. Banerjee, learned advocate appearing for the appellant.
Section 5 for
Learned advocate appearing for the appellant. Praise for
out of time, not put an operator.
an adjournment to appellant করবে. Praise for an adjournment to remove the defects as pointed out in the report of the additional stamp reporter. In view thereof, release the matter before the regular bench on when
Regular bench within a
upon-
week.
Huh?
Within a week, my lord. Regular bench within a week after the regular bench.
Please for press কি বলেছে Mr. learned advocate appearing for the appellant. Praise for an adjournment to remove the defects as pointed out in the report of this. This the matter before the appropriate honorable bench 2 weeks hence. 2
Lord.
weeks hence. Yes.
Well, item number 9, my lord, I'm appearing for the petitioners, my lord, learned easy. And my lord, Miss Susmita Shadoti appearing for the petitioners in this matter, my lord. There was a direction by your lordship, my lord, to serve a notice upon the central boards of worker association, my lord. As because, my lord, they were not appearing, my lord, till still since long time, my lord. My lord, we have served a notice, my lord. They have received, my lord. My lord, if your lordship kindly fix a date for hearing, my lord, because, my lord, learned is not. Is appearing in this matter, my lord.
No. What are the applications?
My lord, brief is not with.
Applications.
Your
disclosed
lordship,
or-
the advocate, senior advocate is appearing on behalf of the respondent.
Sir, we have already come, but appellants, they are not coming, sir. With the plea of the
On the last,
it was instructed to us what is the status of the contempt filed in CAT, Honorable CAT, and they are actually by affidavit already appellants have
contesting the content.
no, yes, sir, content. Then they have already implemented the order of the Honorable Tribunal in 08 566 of 2007. And immediately after within period of 3 months. But they did not actually implement the said order. When the contempt petition filed, then immediately after they have gone to the High Court by a writ.
You have got the relief?
No, sir. No. That have been already revoked and withdrawn immediately.
No, they complied with the
complied for a purpose of only a
No.
Actually, only officially that record they have given to the court by an affidavit. But actually, sir,
My lord, may I, in the nutshell, may I?
মামলা ছিল। হ্যাঁ। What is your problem? Why do you want not to do this matter?
My lord, if you also kindly pass it over, my lord, for half an hour, my lord, she will come, my lord, and
My
do
lord,
the
this is
matter. My lord,
going
we
on
have
for
no
years.
we have no problem, my lord, because my lord, planet is appearing, my lord, and Sushmita Sadat is
What
appearing.
is the subject? What
My
is
lord, my lord, may I make out?
you are for whom?
I am for
We
a
are ready,
edit
my lord.
party can 12 of 2022. My lord, what has happened was after the CAT's order, the Union of India issued a circular which is dated 28/5/2008. In terms of that, that circular was issued in compliance of that order. They complied with. Thereafter, in 2000, this was passed in issued in 2008. Thereafter, in 2010, this appeal was filed. This appeal was filed, challenging the order of CAT.
Though they have issued
They also have complied with. The interim order was refused. Stay over that CAT's order was refused. Now, what has happened is, in the meantime, the employees are retiring one after another. Like myself, I am appearing for 12 retired employees. They take this plea that since the appeal is pending, we will not follow their own circular. My lord, I am suffering because I have retired in the meantime. Some of the retired employees are getting, some of the retired employees are not getting, who have retired after that date. After 2010, whoever have applied, my lord kindly sees that the orders. This honorable court has passed interim orders granting this benefit to other retired employees. I am also seeking, let this appeal be heard out any day, but I should be given that benefit which others are employing. I should be put on the same platform.
Then you are the added respondent.
I am the added
Now
respondent.
the respondents who are there, they have got the benefit.
They have got the benefit. They are enjoying. They are enjoying. The original, the respondents are enjoying.
Have you made an application?
Yes, my lord. It is CAN 12 of 2022. From 22, I am suffering, my lord, because in the meantime, what has happened in Madras High Court, Delhi High Court, and Madhya Pradesh High Court, taking note of the pendency of this writ application, have granted benefit to their employees. Even my lord, this honorable court, the division bench, has passed an order in respect of similarly circumstanced retired employees, granting them benefit of the circular dated 2008. I am also seeking that same benefit. They will not be prejudiced. Their appeal is pending. If ultimately they succeed, everything goes.
Sir, it is a since
স্যার আমাকে একটু বলে নিতে দিন, একটু বলে নিতে দিন, তারপরে স্যার আপনিই বলবেন, আপনিই বলবেন স্যার।
Who is your senior?
My lord, planet is Mr. Ashok Chakraborty is appearing, and my lord, Sushmita Sadat is appearing.
Where are they?
My lord, they have not come to yet, my lord. My lord, if you will
My
also
lord,
kindly
this
pass
was-
it over for half an hour, my lord, they will come, my lord.
My lord, this is the situation going on.
We are ready, my
Since
lord, but she has not
They want
come
to
yet.
hear out the case. This case is never heard out. My lord, I am seeking, they will not be prejudiced. Even interim order is passed. Similar interim orders are on record. My lord, kindly sees the order dated 7/9/2012. There is another order. There is another order.
All right, we take it up tomorrow.
My lord.
No adjournment will be.
No, my lord, no, my
My
lord.
lord, kindly fix it up day after tomorrow. Only day. This.
No, my lord, not Friday, my lord. Friday,
Correct.
she has some personal conversation. My lord, tomorrow, my lord.
Problem.
Sir, every time,
My lord, tomorrow, my lord, not Friday. Only Friday is a personal difficulties, my lord. She has some, my lord. Tomorrow or Monday, my lord, any day, my lord, as per your lordship.
My lord, kindly give some precedence.
Tuesday.
My lord.
Tuesday it will appear.
My lord.
Yes. Next.
My lord, kindly keeps it up at the top, my lord.
How more
No,
precedence you want? Yes, next.
If you oblige, my lord.
মামলা শেষ করতে চাই, এই হচ্ছে আপনি শুনে নেবেন তো, 5 ঘন্টা পরে এসে বলবে
Might be the shell. For the petition. What is the respondent? But, the writ petition before your lordship, my lord, the original applicant, my lord, on the earlier occasions when these matters were taken up, my lord.
no,
This,
Mr. Rai, you argue because my
Yes.
brother was not there.
yes, my lord, yes. But it is with respect to that matter, my lord, where, my lord, the writ petitioner, my lord, initially was, my lord, got the training and thereafter, my lord, was supposed to be, my lord, appointed as act apprentice. My lord, in this meantime, what happens, my lord? He's
Appointed as
act apprentice,
act apprentice.
lordship.
As a what? Temporary.
My lord, substitute helper as substitute helper too. So,
What
my lord,
is the
what happens here,
qualification required?
my lord?
What is the qualification required?
My lord, the qualification was class 8 pass. My lord, there lies the problem here. Because
Why?
the document, my lord, the document which I submitted, my lord,
All
that
right, you
particular,
tell
yes,
us, tell
yes,
what
I tell you,
it is.
lordship. My lord,
You
what happened?
participated in Viva Voci,
Yes,
page 31.
yes, my lord.
Then what happened?
My lord, thereafter, my lord, I submitted, my lord, that I am 8 pass certificate, my lord, candidate. My lord, my document was, my lord, went for verification. So, my lord, the headmaster of that particular school from where, my lord, I passed said that there is no such student in my name. So, he said that it is a fake certificate. Challenging that, my lord, I immediately came before the reasoned order, my lord, was passed by saying that since your certificate is fake, so you will not be given with the appointment. So, my lord, thereafter, my lord,
So they believe the contention of the headmaster. So where is that reason order show us?
Lordship will see, my lord, it is page number 42 to 44, my lord, of my writ petition.
Give us 2 minutes time.
My lord.
Oh, you prior to that you moved the central tribe.
Yes, because it was not being considered. So, my lord, I moved before the learned tribunal, and thereafter, my lord, the order for consideration was passed.
Selected in 98.
I was, yes, ma'am. My lord, before your lordship, my lord, goes into the merit,
Yes.
my lord, when, my lord, this matter was being taken up, my lord, thereafter, my lord, in this meantime, what happens when this matter was, this speaking order was challenged before the learned tribunal, the headmaster, my lord, the present headmaster issued with another certificate by saying that my previous was not right. Basically, he is a student of this school, was the student of this school, and the certificate is genuine. I submitted that document before the learned tribunal. The learned tribunal, my lord, took note of that and said that since this does not contain a particular recognition number and everything, it is not, my lord, it is not a genuine document. Accordingly, rejected my case. I came before this honorable court. But my point before this honorable court was that the learned tribunal ought not have gone to the merit of this certificate, but would have relegated my case, my lord, for the purpose of verification whether that particular certificate was genuine or not. But in this meantime, when this matter was being taken up before this honorable court, my lord on the earlier occasion was pleased to direct me to, because there was a previous original application filed where, my lord, series of persons were there, where the writ petitioner was one of the parties. So, my lord, this has come to my lord's mind that it may be the case that this particular school has got the habit of issuing false certificates to all those persons. This is why all these persons might have filed the original application altogether. So, my lord was pleased to direct me to submit the original application of the previous one, whether the cause of action, that whether the certificate that were issued by the same school or not, to verify. So, my lord, I got that particular original application out and I handed it up to my learned senior. My lord, when my lord was pleased to direct them to take instruction whether that was the case, whether all those original applicants were issued with the same certificate by the same school, which my learned senior will be answering to your lordship today.
You have got that?
My lord, they have filed, 6 persons filed that application original way. And all applications, all persons, it is found that all certificates filed by them are fake. I have filed an affidavit in the tribunal, and subsequently they not pursued that application. Entire application was dismissed. Learned tribunal find that they are not interested to pursue their matter.
In that he was a party.
Yes.
In that he was a party. All the certificates are fake. In one case, 2 cases, schools are not in existence. It is mentioned in my affidavit as well.
That is here on record.
That is, my lord, record of the tribunal. My lord directed them to collect the record of the tribunal. They have collected, and there my affidavit was there. And in the affidavit, it has been stated categorically.
All right, then you place the case.
Yes,
and
yes,
finally decide.
yes, ma'am. Yes. So, my lord, page
And
number.
thereafter, my lord, 1 minute.
Yes,
Sure,
yes.
sure.
And thereafter, my lord, they came before the tribunal. Tribunal passed the impugned order, and impugned order is tribunal did the matter entirely, And if you, my lord, go through the order of the impugned order. Yes, my lord. Yes, my lord.
Yes.
But prior to that, my lord, I want to place only because he has served me. That is that my affidavit filed in the tribunal. In original, yes, in earlier cases, and there I have stated categorically the remark about all the persons that the statement are fake. It is in from page 5 to page.
Then how did he file a fresh application thereafter?
He said, my lord, his certificate also fake, but he somehow managed another certificate from that headmaster, stating therein that he was a student. But in that certificate, headmaster never stated when he was admitted, when he studied over there, that school was whether affiliated to any authority, there is sanction, anything.
Alright,
Nothing was there. That is why
case.
tribunal refused their case.
We will hear you. Let
Yes,
him
my lord.
place his case.
Yes, my lord. Yes, my lord.
My lord, the speaking order, my lord, which I initially challenged. Initially means, my lord, after in 2017. My lord, I challenged the speaking order, your lordship will see, which is at page number 42. It starts. The operative portion may be, my lord, at page number 44. Serial number 5.
Serial number 5.
My lord, page number 44, my lord. Serial number, my lord.
You stated that you passed class 8 from Goa Junior High School. And he was entered in the school on 1980 and left in 88.
Lordship.
That 4 is correct. And
5 and 6 says, my lord, that.
Whereas the headmaster.
Yes.
By his letter dated. Now what he stated in attestation form, that was which certificate?
My lord, this is the previous one.
On the basis of which certificate?
My lord, the certificate also have annexed.
No, paragraph 5 in the attestation form, you stated you passed such and such.
Yes.
And you further declared in the attestation form that the information is correct and complete.
My lord.
Very good. Now, headmaster, by his letter dated 31st March 2005.
Lordship.
In response to a letter of 30th March of the railways.
Lordship.
Stated as per official record, there was no such person, so the certificate is very good. On this ground, your case was rejected.
My lord, I challenged this, my lord, before the learned tribunal. And my lord, the learned tribunal, if I can take your lordship to the order impugned, which is impugned before my lord. My lord, which your lordship will find before, which your lordship will find the order dated 20th September 2018, my lord. The order sheet which is annexed, my lord.
Yes.
My lord, if I can take your lordship, my lord, the reasoning in the meantime, my lord, what happens, because this is a long order, my lord will see, where, my lord, the certificate issued by the headmaster has been taken into consideration. The inspection report was taken into consideration and it was quoted in the order also. Thereafter, my lord, the reasoning was given by the learned tribunal. My lord, if I can take your lordship, page number 7, internal page number 7. I'm sorry, my lord. My lord, it starts from despite, page number 7, man. If I can, my lord, please. Despite such averments in the rejoinder that he filed documents to dispute.
Before that, you read the earlier paragraph.
Yes,
although the school certificate is in issue, nowhere in his
apartment in a pleading. This is a wrong recording because I have specifically avoided the pleading.
His rejoinder, applicant made the following statement. What I further state document.
I further state and submit that the documents which your applicant could not annex at the time of filing the original application, since at that time those documents were not in possession of the applicant and during pendency of the original application, your applicant collected the said documents,
Those are very vital for adjudication of this case and annexed in this rejoinder, by which it can be proved that the statements made by the respondents in the reply cannot be accepted in the eye of law. That was my averment. Thereafter, my lord says, despite such averments, in the rejoinder that he filed document to disprove headmaster's contention dated 31st March 2005, there are no annexes to the rejoinder to prove his case, and we are unable to accept any statement of the applicant that he is in possession of such documents that effectively disputed the certificate dated 31st March 2005 of the headmaster of Goaberia High School. I'm not, my lord, saying that there might be a mistake that which I did not do. Thereafter, my lord, sees the next line. During hearing, the learned counsel for the applicant draws attention to certain documents which have been taken on record. So those documents are taken on record and lying before the learned tribunal, my lord. It transpires therefrom that another headmaster of Goaberia High School on 14th of July 2017 has certified the applicant as the student of his institution and has annexed a transfer certificate dated 7th of June 1994 to this effect. The transfer certificate appears to have been issued on 7th of June 1994. The applicant had applied for the job of Group D with the respondent authorities on 6th of January 1995. As per the application form annexed to the reply, if so, the applicant must have been in possession of the transfer certificate dated 7th of June 1994 at the time of submitting the application in 2005. However, the concerned headmaster had denied to issue any such transfer certificate. The applicant has not been able to explain satisfactorily as to why he waited till December 2015 to represent against the non-absorption in 2005, and why the certificate dated 14th of July 2017 purportedly by another headmaster of Goaberia High School does not bear any recognition number of the said educational institution, unlike the headmaster's certificate dated 31st March 2005, which clearly disclosed such and such dated 17 January 2005 as the recognition number of the said date of recognition. As the school was reportedly recognized in 17th of January 2005, further questions arise.
Mr. Rai,
my lord,
please tell us, when
Yes.
was the advertisement? Advertisement was December 2015.
No, my lord.
No.
That was long back.
Long,
That was, my lord, in
1994.
1994 and 1996 subsequently. But what happens?
1994 was the selection.
Yes, my lord. I was issued with a call letter, which is, my lord, at 1998, which is at page number 31.
Very good. So when you
My
in
lord.
the attestation form, that statement you made was relying upon the headmaster's certificate of 31st March 2005.
5. Yes,
Now in 31st March 2005,
my lord. My lord, that particular certificate, my lord, was verified, and it was the headmaster said, no, I did not issue this kind of certificate. This was
the person
fake
who
certificate.
issued the letter. Now thereafter you got hold of another transfer certificate, another
certificate of the headmaster.
another of the same school.
Same school.
That you got when?
My lord, my lord, I tell your lordship, my lord, because the certificate is itself annexed.
New certificate.
New certificate.
That is
My lord,
14th of July 2017.
17, my lord. That your lordship will see the previous page to the order impugned. Just the 70, it would be 80, page number 80.
Yes.
So, my lord, this is the subsequent certificate, my lord, which I handed up to the learned tribunal at the time of hearing.
Please tell us.
I'm sorry.
Your application was on the basis of 98 selection. You said, when was the call letter?
My lord, the call letter lordship will find at page number 31.
What is
which
the
is,
date
my lord,
of-
1998.
So how with that?
My lord, that in that particular, my lord,
when did you fill up the attestation form?
my lord, that your lordship will find page number 34.
34 provisional appointment.
Provisional appointment I was given. but I was never, my lord, appointed. For which, my lord, I went before the learned tribunal by saying why I am not being appointed.
Very
My lord, thereafter, my lord, the tribunal said that you go representation to be considered. Thereafter, my lord, it was disclosed that my certificate was not right. The headmaster says,
What I am saying is
yes,
your attestation, your selection was in 98.
my lord,
Provisional appointment was in 2004.
4.
When did you fill up the attestation form?
My lord, that particular attestation, my lord, form for act apprentice, my lord, was of 1990. I tell you, lord.
Now, how can it be how if 1998? How
My lord.
could you have annexed a certificate of 2005?
My lord, I at that particular time I only disclosed that I passed class 8. If I can take your lordship to page number 32, there was no certificate at that time.
Observation of the tribunal.
My lord, lordship will kindly seize once. My lord, page number 32, my lord.
No, no, the attestation you just now showed us, no,
My lord,
which
yes.
has been quoted.
At page number 32, your lordship will find that my disclosure that I am a class 8.
Where is this attestation you just showed?
My lord, page number 78 is the certificate of 1994 which I annexed at the time when I filled up the form.
No, no, that attestation observation reason order.
My lord,
Yes, page 44.
yes, my lord.
Page 44 in
Yes.
the attestation from point 10, you
page-
stated this and you submitted. Oh, in the attestation form, you did not annex any certificate.
No, my lord. I only
Now,
disclosed that I am a class 8.
you
That your
class-
lordship will
now
page
they
32.
conducted an inquiry.
Inquiry. Your lordship will kindly seize, my lord, page number 78 is the certificate, my lord, that everybody is talking about here.
This is a 78.
My lord, this page number, yes, 78, my lord, is 7th of June 1994. So, my lord,
This is a fake certificate.
they say yes.
This is 7 June 1994.
4. If I can take your lordship to page number 73 once, my
No,
lord.
no, where is this headmaster certificate of 31st March?
Yes.
It is, my lord, page 80.
My lord, page number 80, lordship sees the new one.
That is the new one.
Yes.
Where is the
I tell you,
31st
Lord.
March 2005?
It is page 75, my.
75.
My lord, page number 74, 73, if your lordship sees from 73, because that is the document, my lord, which was sent to this headmaster that you verify this certificate, whether it is genuine or not. That is page number 73. And the answer, your lordship will find at page number 75.
Then what is the 78?
My lord, page number 78, my lord, is the original certificate which I, my lord, submitted. That was, my lord, sent for verification. And the result of the verification is 75. Which is against me, my lord. Now, my lord, problem here, my lord, I made the problem here what? Is the transfer certificate which I did not, my lord, submit, my lord, at the initiation.
Which transfer certificate?
This page number 78. That was handed up to the learned tribunal at the time of hearing. Along with page number 80. So, my lord, now, my lord, my point only before your lordship, because when this was, my lord, taken on record. Now, thereafter, my lord, the learned tribunal, what has been held, my lord, lordship will see, internal page number 7, lordship has already seen in the order impugned. Internal page number 7 says that it does not bear any recognition number. Internal page number 7, serial number Roman 3.
Yes.
That the applicant,
Next
yes,
paragraph.
yes, the applicant has not been able to explain satisfactorily why did not he produce purportedly by another headmaster does not bear any recognition number of the said educational institution, unlike the headmaster certificate of 31st March, which clearly recognize such and such. Now, the question, my lord, the tribunal, my lord, raised, lordship will kindly seize this. As the school was reportedly recognized in 17th January 2005, further question arises. Did the applicant attend 1988, a school not recognized in the Board of Education? My lord, always, my lord, the recognition definitely, my lord, can come afterwards, my lord, my lord. B, who is the issuing authority of the transfer certificate and which school had issued the transfer certificate, as the identity on both fonts are totally illegible in the transfer certificate of 1994. These are the questions that the applicant has failed to answer conclusively. And hence the genuineness of the school certificate of 2017 cannot be accepted as a conclusive one. Hence it is rejected.
Now, who is the issuing authority of transfer certificate? That
My
is page 78.
Yes. My lord, page number 78, my lord, is the headmaster who issued in 1994. Lordship, at the bottom, lordship will see there is an index number written in page number 78. My lord, that is in 2015. Lordship will kindly seize that. Because this has fallen from the learned tribunal in the meantime that there was no such document, or the petitioner also could find that no index number or nothing is mentioned. He went before the school and said that you kindly mention the index number, otherwise I am facing the problem.
That you went after 15, that is after 20 years.
Yes. So, my lord, it is 16th of September.
How
index.
can this disputed question be gone into, Mr.
This is exactly my point is. My lord, these could have been, my lord, sent by the learned tribunal to the authority concerned for seeing whether these documents are right or genuine or not.
That High Court will reject now.
My lord, I just beseech your lordship.
In judicial review.
My lord, subject to correction, my lord. The learned tribunal, my lord, without, my lord, doing that particular thing, my lord, went into, my lord, in finding out whether this transfer certificate are genuine or not. And my lord, what are the question issues framed?
That is page 80.
Yes.
The new headmaster said that it is genuine.
It is genuine. So, my lord, now the learned
this was disbelieved by the
tribunal. By putting, my lord, by framing some questions, which lordship will see the merit of the questions. Because it said that the recognition is in 2005. How can you be of 1998? My lord, lordship knows after, my lord, the 1968. Yes.
Did the applicant till 1988?
Yes.
A school not recognized by board.
Board of Education, my lord. My lord, if school can always be recognized afterwards, my lord. Everybody knows that.
Which school had issued the transfer certificate?
So the headmaster has issued the transfer certificate.
Oh no, transfer certificate is at page
78, my lord.
78.
Yes.
This which school? This Alok Kumar Guin.
Yes.
Headmaster of.
My lord, of this particular such and such Howrah school. So this is why, my lord, these documents were required to be, my lord, found out whether they are genuine or not, since they are taken on record. So my respectful submission before, I'm not beseeching a lordship, my lord, now today that I will be given appointment without verification or nothing else. I just beseech, my lord, that the learned tribunal are in law, my lord, in going into, my lord, the merit of this application without, my lord, giving the respondents also any opportunity whether these documents are right or not.
Entire claim is on the basis of 14 July 2017 circular.
My lord.
Where the new headmaster says that there was no such student in my school.
My lord, that is the previous one, which went against me. My lord, page 80 is in my favor.
14 July, another headmaster said that school was upgraded, he was there.
Yes.
The genuinity of the certificate has been disputed.
Yes, my lord.
So when the genuinity court said that it is right, it bears no memo number.
My lord,
it bears no index number recognition of.
It does, my lord, which your lordship will find at page number 78.
No, come to 80. This is a memo number is blank. It is a random certificate issued.
It is given, my lord. And also, my lord, page number 78. It is a transfer certificate also. My lord, page number 78. It is also a transfer certificate contemporaneous, my lord. Now, my lord, I just respectfully, my lord, submit to your lordship that the learned tribunal ought to have given the respondents at least the opportunity to go deal with these documents. if it would have been found that these are not genuine, there is no such recognition number, nothing is there, index number is mistaken, I would have been, my lord, out of this court. My lord, the learned tribunal, my lord, went into the merit, that too, my lord, on some consideration which, subject to correction with deepest respect, my lord, cannot be right. That in 2005 you got recognition, how could you be in 1982?
Yes, yes. What? This is your argument.
This is my respectful submission to you.
Anything else, Mr.
My lord, only with respect to the previous original application, my lord, which has been, my lord, addressed by my lord senior, that all those original applicant certificates are fake. Maybe all those certificates
We are not going into that. Let us hear this.
Great.
My lord, I've already
Yes, Mr. Bhumik.
My lord, I already stated they have filed their application for Act Apprenticeship application, stating therein that they are 8 pass certificate. They are 8 pass holders. They are specifically warned them that if you file any wrong certificate or wrong declaration, your candidature will be disbelieved or not considered. My lord, it is page 31. My lord, kindly come to page 31 once.
Just one clarification. Mr. Roy, kindly come to internal page 6 of the order impute. So your the reasoned order was passed on the basis of an earlier order of tribunal on 21st March 2017.
Lordship.
Now, internal page 6, that quoted portion.
Yes, madam.
This rejoinder was filed in this way.
The quoted portion, my lord, is the.
I further state and some documents which your applicant.
Yes.
And it says, since that those documents, the applicant and during pending, you have collected the documents which are vital for adjudication and annexed to the rejoinder. Despite such, he filed documents.
Yes.
He filed documents to this. There are no annexures to prove.
Yes. This is with respect to, my lord, this.
In the rejoinder, you did not annex, but at the time of hearing, you produced. Yes, Mr. Bhumik.
My lord, at page 31, my lord.
31.
Yes, my
lord.
It is column number 7, my lord, bottom. The bottom, your candidature will be cancelled if any irregularity is found at later stage. It should be chief horseman. My lord, page 32. At page 32, my lord. Next page. They said that they have passed class 8 as column 5.
Yes, passed class 10.
Class 8, my lord. That are technical. That is cross, my lord.
Passed class 8.
General.
Acha. Yes.
Class.
Yes.
So, on the basis of that documents, they have filed at that time that transfer certificate supporting class 8. My lord, they have got the letter for appointment letter. It is page 34. In this said appointment.
The transfer certificate at page 78.
Page 70. In page 35, my lord, serial number 16, you are hereby warned that if any false misleading information is furnished or there has been suppression of any factual information in application form, your service could be liable to be terminated. So subsequently, my lord.
No, that is okay. That we understand.
I just chronology. My lord.
Yes, yes.
So
tell you.
thereafter, my lord, inspector was deputed for verification, getting verification of that certificate. One inspector of the department deputed for verification of original certificate, which was filed by the appellant. My lord, headmaster Mosai, by a letter dated, stated that 31/3/2005, my lord says that there is, as per the official record, there is no such, as per the official record, there was no such above mentioned student reading in this school. So this is a fake certificate. This school was recognized by the West Bengal Board of Secondary Education with a recognized number to such. On the basis of this, my lord, their appointment was not considered in the year 2004-5.
In the year 2005. That is the recent order was.
Yes. No. Recent order. Subsequent recent order was subsequently.
Achha.
2005, man. Then in the year 2000, thereafter, a group of 6 persons filed an OA application in tribunal seeking appropriate order. They are
of the same school?
No, of different school. Then we have filed the reply stating therein that all the certificates are fake. In 1-2 cases, schools are not in existence. So thereafter, they did not proceed with that matter, and tribunal find that they are not interested, and tribunal dismissed the OA. Then present appellant in the year 2015, my lord, they filed another, they submit on representation before the authority. Authority considered. Second, in OA, OA, they filed that present appellant in pursuant to that order passed in OA. In the year speaking order was passed.
Where is that representation on the basis of which the speaking order was passed? 22nd December 2015.
Yes,
that is page 36.
Right.
So that was even prior to the certificate subsequently obtained.
Yes, yes, yes.
প্রথমে যে সার্টিফিকেট সেটা ফেক সার্টিফিকেট, সেটার পরে ও যখন একটা চ্যালেঞ্জ করলো তখন সার্টিফিকেটটা প্রডিউস করলো, কিন্তু যখন হিয়ারিং হচ্ছে ট্রাইব্যুনালে এই পেজ এইচডিটা দেখা। Yes.
So this appellant got the information that his candidature not considered due to that fake certificate. He took no steps, and in the year 2015, of 10 years long, he then made a representation, and thereafter filed second way, and in second way directed to department to pass a speaking order. We have passed a speaking order. Thereafter, my lord, in the year he filed another way challenging that speaking order. In the even at that application also, he did not annex any documents in support of their bona fide.
Where is his representation of 22nd December 2000? That is page 36.
Right.
No, provisional appointment was of 2004. You did not allow him to join. So he made a representation in 2015.
Yes,
That was directed to be considered.
right, my
You rejected his case. Then he filed an original application
right, my
without enclosing the certificate on which reliance he was placing. He placed that certificate when the tribunal was hearing the matter.
he did not place what certificate he relied upon, that original transfer certificate and the Golavedia certificate headmasters passed. He never challenged that certificate even. At any stage, that certificate is wrong.
Which certificate? That page 75.
Page 75.
How will he know that you have rejected on the basis of 2005? He approached the tribunal, that is why.
My lord, I have disclosed in my affidavit in opposition. I have intimated them also definitely.
All right.
So he did not challenge at any stage, my lord, regarding that certificate. Subsequently, my lord, he has managed to get another certificate from headmaster of that school. That certificate also very vague, never stated on the certificate when he was admitted in that school, when he passed, what is no details, nothing. It is only mentioned that he has even my lord, surprisingly, he is holding the transfer certificate since 1998. 94 even. He never disclosed that certificate before any tribunal, before any authority. Only he disclosed that certificate last moment when final order was going to be passed by the learner tribunal.
No. 94 circular, 94 certificate he annexed.
No, my lord. No, my lord. That is the observation of the tribunal also.
Show us that. That must have been in his application form when he applied.
The transfer certificate appears to have been issued. The authority, the application of the transfer certificate at the time of the.
When did he apply?
He applied India to applied for in rail
for the appointment.
2004, 1994, my lord.
At
for,
that
for act apprentice. After completion of training, he got the appointment.
There he stated that I have passed class 8.
Yes, and annex that certificate, that transfer certificate
of 94.
Of 94.
So what is the wrong?
Nothing wrong, my lord. That certificate was verified. Subsequently.
That you have said.
Subsequently. And the headmaster said there is a fake certificate. That certificate of the headmaster not challenged. That certificate, my lord, in any way, what tribunal tried to say, in way, they never annex that certificate, what he is relying.
The 2017 certificate.
No, my lord, even transfer certificate, which was at the time of hearing, he has.
That is 2017 certificate, not 94 certificate. He was placing reliance upon this certificate. 78.
My lord.
Where do you show?
Page 7, my lord.
Huh?
First paragraph. Last line of the first paragraph. As the student officer, I am reading the entire sentence. It transfers therefrom that another headmaster of Gorabay has certified the applicant as the student officer and has annexed a transfer certificate. Transfer certificate means that certificate, my lord, dated 7/6/94. So, tribunal observed that he never annexed that certificate even with his applications in any way. He not submitted that even with his rejoinder also. That is, I believe, that is the observation of the tribe.
Applied with the on 9th. Transfer certificate appears to have been issued on 7th of June 95. Applicant applied for job on 6th January 95. As per the application from annexed to the reply. If so, the applicant must have in possession 94 at the time of submitting his application. Stop. In 2005, however, they has. Yes.
Oh my God, this is very, very pathetic.
Yes, Mr. Roy, you did not annex the 9th or 7th June 94 certificate.
But in the original application, I cannot assist your lordship whether I did or not. But it was there in the form if your lordship sees page number 73.
73?
3. My lord, this is the
That must have been there, otherwise how they could
lordship
have
sees 73.
undertaken verification.
Yes, my lord, this is what written. Your cooperation, my lord, has got page number 73. Your cooperation is sought for in connection with the verification of the school certificate which is enclosed herewith to serve the obligatory duty of this administration. That was the document, my lord, which lordship will kindly seize the date. On the earlier occasion, lordship has taken note of that as well. That was in 30th of March 2005, page number 73. When the headmaster replies, page number 75, 31st March, on the very next day itself. No, there is no such document. And thereafter, my lord will see, my single prayer, I will not, my lord, in reply, my lord, only that tribunal accessed in jurisdiction. Exercise jurisdiction, my lord, which is not vested in the learned tribe. That is my only point before, my lord. Because this is a, my lord, matter of job of an unemployed person, my lord. Lord, you would kindly take note of this.
The present writ petition has been preferred, challenging an order dated 20th of September 2018, passed by the learned tribunal in the original application, being OA 986 of 2017. Stop. Mr. Royal, under the advocate appearing for the petitioner, submits. That the petitioner upon emerging to be successful in the selection process, was empaneled as act apprentice for trade apprenticeship training. After successful completion of such training, the petitioner was issued a letter of provisional appointment. On 27 December 2004. He filled up the verification form stating that he passed class 8 from Goabedia Junior High School, Howrah. Stop. Bracket A, in short, the said school. Stop. He took admission in the said school on 19th February 1980 and left the school on 31st December 1988. The respondents, stop. Uh, as the respondents thereafter did not issue As the respondents thereafter did not allow the petitioner to join, he was constrained to prefer an original application, which was disposed of by an original application being OA number 350/01446/2016 on 21st March 2017. Directing the respondent number 2 therein to consider the petitioner's representation dated 22nd December 2015. Pursuant to such direction, an order was passed by the respondent number 2 herein, rejecting the petitioner's claim. Aggrieved thereby, the petitioner preferred another original application being OA 986 of 2017, which was rejected by the order impugned in the present writ petition. Drawing our attention to the next paragraph, drawing our attention to the contents of the order impugned, Mr. Roy submits that the learned tribunal framed a question to the effect that, বলে কোট আনকোটে পেজ 8 আছে এটা, হ্যাঁ, একটা সিঙ্গেল ইনভার্টেড কমা দিয়ে আইটালিক্সে দিয়ে দেবে, স্টপ। The said issue was however not decided. The framed in কি বললে framed and framed a question to the effect. Stop. No, ওটার সাথে continue. In view thereof, the learned tribunal ought to have relegated the matter for consideration of the said question instead of rejecting the original application. Mr. Roy further submits that the letter dated 31st March 2005 issued by the previous headmaster of the said school would not have struck down the validity of the transfer certificate issued by the competent authority as annexed to the present writ petition at page 78. Stop. He further submits, next paragraph, he further submits that there was also no reason to doubt the veracity of the subsequent letter issued by the headmaster of the said school on 14th of July 2017. In the said conspectus, in the said conspectus, according to Mr. Roy, the order impugned needs to be set aside with an appropriate direction upon the competent authority to consider the petitioner's claim afresh. Next, Mr. Bhomik, learned advocate, appearing for the respondents, however, denies and disputes the contention of Mr. Roy. Drawing our denies and drawing our attention to the contents of the letter dated 25th January 1998. He submits that there was a specific clause that the stating, quote unquote, your page 31 এ আছে clause 7 টা quote unquote দিয়ে দেবে, in spite of being aware of such condition. Stop. 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 The ওটার সাথে কন্টিনিউয়েশন দেবে। Stop. In the ওটার সাথেই দেবে, in the provisional letter of appointment dated 27 December 2004, there was also a clause to the effect বলে quote unquote page 35 টা দিয়ে দেবে। The in view thereof, the respondents have every jurisdiction to cancel the candidature of the petitioner as the document towards his qualification was certified to be fake by the headmaster of the said school through a letter dated 31st March 2005, issued in course of verification issued in course of verification of the school certificate conducted by the respondents. He further argues that the subsequent certificate letter dated 31st March 2005 was not issued by the headmaster of the said school, was not challenged by the petitioner. He, however, annexed a further letter issued by another headmaster of the said school on 14 July 2017, indisputably subsequent to the filing of the application being OA 986 of 2017. According to Mr. Bhomik, Mr. Bhomik হবে respondent. According to Mr. Bhomik, the learned tribunal, upon considering the factual issues, had arrived at specific findings, and the same does not suffer from any infirmity warranting interference of this court. Heard the learned advocates appearing for the respective parties and considered the materials on record. Stop. the learned tribunal in the order impugned observed inter alia that the petitioner had failed to explain satisfactorily as to why কি লিখলে? The learned tribunal, in our opinion, next one, indisputably, এটা কেটে দাও, indisputably, comma, the transfer certificate dated 7 June 1994 in course of verification was not found to be genuine, as would be explicit from the letter dated 30th March 2005 issued by the then headmaster, 31st March 2005, by the then headmaster of the said school upon scrutinizing the official records. Stop. The said letter dated 31st March 2020, the effect of the said letter dated 31st March 2005 had been sought to be diluted by production of a new certificate dated 14th of July 2017, comma, that is about 12 years after the issuance of the certificate dated 31st March 2005. And even subsequent to filing of the original application, being OA 986 of 2017. In the said conspectus, the learned tribunal rightly questioned the veracity of the said certificate dated 14th of the said certificate 14 July 2017. More so when the same did not even disclose the more so when the same was bereft of a memo number. Stop. The argument of Mr. Roy that the matter needs to be relegated for further consideration in view of the question framed by the tribunal, comma, as quoted above, is not acceptable to us. So, considering the documents produced and the relevant facts, the learned tribunal arrived at specific finding, and we do not find any patent error of law warranting interference in the present writ petition. Accordingly, the writ petition being such and such is dismissed. There shall I. Sorry, Mr. Roy.
As your lordship, please. Grateful.
Pen drive button. হ্যাঁ তাই করে
চলুন
Yes.
Lord, item number 11 is an appeal, my lord, appeal papered by the state. Well, this is an appeal papered by the state.
What is the issue, Mr.?
The issue is this, that my lord, some retired employees of Calcutta, North Bengal State Transport Corporation, in short NBSTC, they are, my lord, retired pre-1996, prior to 1996. Now, they said that they belong to such a group because of the pre-1996 retired employees. Their pension amount much less than the pension received by the, or used to receive by the, my lord, the Calcutta State Transport CSTC employees who retired at the same time. Both are, my lord, the transport organization. Now, according to them, there is a circular of 1998.
So issue is parity of pension.
Issue is parity of pension. Issue is parity of pension.
On what ground the tribe learned single judge
I'm
held
coming. I'm coming. Now, my lord, unfortunately, my lord.
No, why we are saying Mr. Sen?
Yes.
Because this bench will.
It will take time. It will take time. I'm coming this. It will take time. Now, my lord, when the writ petition was taken up, unfortunately, none appears for neither for the state nor for NBSTC. No affidavit was, my lord, exchanged. Now, prior to this writ petition, the order it has been mentioned therein, prior to this my lord, the last writ petition, there was earlier writ petition filed by this group, writ petitioners. In that writ petition, while the same was disposed of, an order was passed giving liberty to the writ petitioners to make their appropriate representation before the principal secretary of both transport department as well as finance department. That writ petition disposed of directing this. On the basis of that liberty, representation was made by the writ petitioners both before the principal secretary transport department as well as to the principal secretary finance department. Now the transport departments, the principal secretary transport department disposed of the representation without considering the views of the finance department. According to that order annexed to the subsequent writ petition, the transport department view is that we sought for the view of the finance department, but they did not send any views or so. In any event, they are not entitled to. I mean, there was no, my lord, the specific expression with regard to the reason. But so far the representation before the principal secretary, I'm coming to Lordship. My lordship need not go, my lord, the first, my lord. So,
no, we are wanting to know what is your stand. You did.
I'm coming to, but lordship kindly hear me.
Affidavit.
No, my lord, no affidavit was filed. Now, my lord, may I tell? My lord, this was the, my lord, the fate of the representation before the transport department principal secretary. Rejection, but no such, my lord, such reason not elaborate. But so far the representation made before the finance secretary, principal secretary finance department, it was, my lord, taken. Now, a threadbare discussion was there after giving hearing to all. And eventually, my lord, the rejection was there, but the reason that has been, my lord, elaborately discussed is this, that so far the pre-1996 retired employee.
Writ petition was preferred challenging the
observation as well as the rejection of the, my lord, by the principal secretary finance department.
And not challenging the order of the transport.
No, because this is the vital.
Now transports held in their favor.
No.
But they did not challenge that order.
They challenged this.
Finance secretary.
Finance secretary. Now the finance secretary, after giving, my lord, hearing to all, rejected on the ground that though their claim is that they are entitled to the amount of the pension amount which is being received by the same, my lord, the similarly circumstanced employees of CSTC,
Now, they are not entitled to, so far NBSTC similarly circumstance employees are concerned because of the fact, in gist, my lord, because of the fact, though elaborately discussed, but in gist is this, because the 1998 ROPA, when it was given effect to, because 1998 ROPA was given effect to, my lord, sometimes from 1996. At that point of time, in 1996, prior to their retirement, this 1996 ROPA pay revision was given effect to, so far this set of employees of NBSTC was concerned. Because their whole claim in the representation as well as in the writ petition that they are entitled to 148% DA should be added to the basic, they last received the basic pay. This 148% DA having not been added, they said that it is 50% DA added, but it should be 148% on the last basic pay, which is given or which is, my lord, which is being received by the similarly circumstanced CSTC employees. Now, the answer given in that, my lord, the disposal of the representation by the finance secretary is that the NBSTC employees of pre-1996 employees are not entitled to 148% DA to be added to their last basic pay because already they have that basic pay already enhanced on the basis of the 1990 ROPA. And that DA already included in their last basic pay. But so far the CSTC pre-1996 retired employees were concerned, their basic pay was unrevised basic pay. And that is why at the time of pension calculation,
disparity arises.
Disparity arises because of this. The CSTC retired employees basic pay of pre-1996 on the basis of pre-revised pay scale. Pre-revised means 1990 ROPA was not given effect to in their case.
Then it will become same, Mr.
So, but in the case of the NBSTC, already given effect to the revised pay.
So that revised pay, if that they have already availed.
Already given effect to.
And CSTC availed in 1996, subsequent ROPA. Why is the difference in the
difference? Because of the fact the entire calculation based on whether the 148% DA is to be added to the last basic pay of the NBSTC pre-1996 retired employees or not. Because my lord, because already that benefit has been given effect to when my lord, the revision of pay has been, my lord, allowed. But similarly, so far the CSTC pre-1993 retired employees are concerned, this benefit was not given effect to. So their calculation was on the basis of pre-revised pay. And since pre-revised pay, so in their case, 148% DA added to the pre-revised basic pay. And here they are not entitled because their pay already revised.
Yes, Mr. Prasad, how can we finish it off? Because this bench will again change.
Yes, my lord.
Will be here for 3 days. Justice Velumoni will be returning on 28th. And so far as I could gather, her ladyship would be there, would be my regular bench is with her.
I know.
And this is the predicament we are also facing.
Yes, my lord.
It will
We are
take time.
trying to take up motions and dispose of, or we are trying to hear and dispose of matters being in this. Otherwise, again Pathard, again another. And we understand your anxiety. They are very aged persons, you have already told us.
And another issue is also there that whether the employees of undertaking should be or can be treated as a government employee, because they claim that we are also government employee. So these are all the issues involved herein.
ভেলুমনি ম্যাডাম কি ওই 4 তারিখের পরে ওটাই থাকবেন?
here, my lord, as my lord Justice Uday Kumar is also is there, my lord, till 24th. My lord, the issue is very short. My lord, why I am saying so? My lord, here the moot question is a wrongful calculation of the pension, and my lord, an entire background of the case is that, my lord, the ROPA 1998. My lord, and what happened, my lord, then, my lord, I am submitting, my lord, why I am saying so. Yes, my lord, whenever a ROPA was promulgated, my lord, there is a point of reference.
No, Mr. Prasad, let us do one thing.
Yes, my lord.
Her ladyship would be returned
Yes,
on
my lord, I am not.
28th.
Yes.
On 28th. We are keeping it on 28, 29 we are keeping, and we will fix a time and date when her ladyship would be there and we can fix.
Yes, my lord, I will not come on that.
Now, in the writ petition, no affidavit was exchanged.
Yes.
That is why, my lord, I cannot, my lord, make it as a part of the paper book. Since
But have you prepared any sort of note?
no, my lord, if your lordship, my lord, kindly, my lord, give me leave, then I can file, my lord, an affidavit, because the appeal court can give me leave.
Paper book has been filed.
Paper book filed.
So, if you want to prepare a note, you can prepare and give a copy to
Very
him.
good.
And
Yes.
those documents we can take on record.
Very
Not a written argument, but the fresh
still,
documents.
yes.
We will
Then, my lord,
listen.
I shall also, my lord, annex certain documents with regard to the calculation of the pension, so far the writ petitioners are concerned, so far whether the consolidation has been given effect to or not, because the earlier order was there that whether
Then why
consolidation has been
didn't you
given
pray for pray for a reply when the paper book direction was given? You could have made a prayer to that effect. Any such direction was there?
No, my lord.
Any Mr. Prasad, any such direction was there?
Yes, my lord, what happened, my lord, on the self-same issue? Self-same
সেটা তো
issue.
আদার কথা, ওটা ছেড়ে দাও না, ওটা
Yes.
তো গেছে, ডিসমিস হয়ে গেছে, ওটার কথা গল্প না আনছো কেন? তাতে লাভ
Whether
কি
you
হবে?
file
তাতে
an
লাভ
opposition
কি
to the
হবে?
stay application, proceed with hearing.
না বলতে
He
তো
has opted for the latter course. So you did not want to file.
Yes. Now, my lord, the issue that has been framed by the coordinate bench,
Yes.
it is on, kindly consider, order dated 22nd of January 2019.
We have read it. We have read it. So two issues have been framed.
And on that basis,
But one of the issues so far, the, my lord, the government employees, my lord, the pension regulation is concerned, that is not at all, my lord, applicable in the present case, because here
Mr.
a separate
Selvi,
pension regulation
I
is.
do not want to place reliance upon any fresh documents.
Yes, yes.
Whatever writ petition was there, that was there.
No, he does not, but I want to.
The writ petition, have you filed any opposition?
No, that is the whole one. No opposition filed, lordship. No opposition
My lord,
filed, none appeared.
what happened, despite direction, they choose not to file.
No, no.
And another thing, my lord, that I want to point out, my lord, on the self-same issue, the another writ petition was moved by
There are
another
dismissed
similarly
because, my lord,
এক second একটু বলে দিই।
না না কি বলবো, আমি তো বলছি।
Another similarly situated person. In that writ petition, my lord, affidavit was exchanged and the writ petitioner claim was upheld by the, my lord, honorable single bench. My lord, and in one of the occasion, my lord, the appeal was preferred from that order also. And one of the occasion, my lord, these two matters, my lord, this matter and that matter was taken up, my lord, analogously. Now the difficulty is that in that matter, the writ petitioner respondent, my lord, died in the meantime, and he had left no legal heirs. That is the whole difficulty.
And that was, my lord, when the matter was taken up before the division bench.
No, in that writ petition, there were affidavits.
They have filed the affidavit.
There
My lord,
the affidavit was exchanged.
So that is your contention, what you have said that
Yes.
in the affidavit.
Almost, yes, yes. But the difficulty is that appeal is, my lord, no more, my lord, in the record, because that appeal already, my lord, stood dismissed. Because when the matter was taken up, my lord, I was there also, my lord, the state was the appellant and the state was directed to take instruction.
That affidavit is with you. Do you have
Copy
that
of the affidavit? Yes, my lord.
And their reply also is
Their reply also. No, my lord, but that matter, my lord, because of the death of the soul, my lord, the read petitioner come respondent. And since my lord, no heirs, my lord, left behind, my lord, he is not survived by anybody. So, my lord, the ultimate, my lord, the effect is, my lord, the dismissal of the.
And my lord,
এইসব কিছু বলেই মিস্টার সেন
my lord, another thing, my lord, perhaps in this matter, my lord, there is no requirement because it is a completely pure question of law. And my lord,
Mr. Sen, you did not, when the matter appeared before Justice Sen, you did not pray for any opposition also, that you let me use an opposition. Nowhere,
I
Mr.
think
Sen, it was.
the orderটা কোথায় গেল? orderটা পেয়েছো কিছু?
my lord,
Order was 10th of December 2019, 7th January 2022. Mr. Sen, you do one thing. You, whatever documents, any other document you want to rely,
My lord.
informally you give us head to Mr.
Yes, my lord, I have no issue.
And when we finally hear, we will deal with your arguments.
Yes,
My lord.
I have no issue.
My lord, only document is that it is this, my lord, 17 September 2009 circular on the
Very
basis
good.
of which
We
the
will
pension
record
is
that
being
in our order.
calculated. Now, my lord, the only thing is that the one of the, my lord, the issue that has been, my lord, the framed that the whether that, my lord, the consolidation has been given effect to. I want to show that yes, the consolidation has been given
So,
effect.
Mr. Sen, you give a copy of that document which you are placing reliance
My lord.
upon Mr. Prasad.
Very.
And because we are now, if we say that you file an opposition, that will be contradictory to the earlier orders passed by the coordinates. This is our difficult. Otherwise, we would have done. So you give a copy which you are relying that document to Mr. Prasad. We will hear from him so that you can place the document. We will hear. We will record that that document was in record in earlier writ petition. What is the problem?
My lord.
ওটাই দেবেন তো স্যার
Tell me when can you come, give a copy and come back to us. But when Justice Velumoni comes and sits, otherwise the matter cannot be heard out. No?
My lord. It will take some time. Very good, lordship. On my lord, any day, my lord, if, as my lord, let my ladyship
You
come.
agree to a date.
my lord, next week, my lord,
Next week আসছে না next week কবে আসছে 28
এটা কি 7 তারিখ রেখে দাও লিস্টে দেখা যাক 7th
7th
7th.
But my lord, one thing, lordship, my lord, I beg to your lordship, my lord, that the appeal court can direct, my lord, to my lord, because the power
You
of
can
the
direct to bring the records of that matter.
that is true, and at the same time, my lord, my humble submission is that
Yes.
that appeal court can also direct, my lord, my lord, to the parties to bring any document because
After
of the
filing of
power of
paper
the
book.
appeal court.
After filing of paper book.
But supplementary, I think, your lordship so direct. By one of the supplementary affidavit be treated as a supplementary paper.
We then
Because order 41, I think, my lord, that power is given, my lord, because to the appeal court, that all the power which
you do one thing. You prepare a supplementary evidence.
my lord,
annexing the documents.
My
Give a copy to Mr. Prasad. You use a reply. We are not passing that order. Once you complete that,
Yes,
we will
yes.
take it on record and hear the matter.
My
and another, my lord, if
So,
my
Mr. Sen, you do it within a week. Give a copy to him. He will do it within a week. We keep it. Let the matter appear in the regular bench on
7th.
On 7th. 7th, will it be possible? Because today we are on 22nd. আজকে কত তারিখ? আজকে 22 তারিখ. 1 week will take us to 29th. Yes. We keep it on
12th December.
my lord, can it be before that, my lord? If my learned friend
All right, we keep it on 8th of December. That will be a Friday. On that day, we will take it on record and fix a particular time and date. All right. Subject to my
Yes, yes.
birthright. ডেকে দাও চল
But before rising, my lord, next item is my but only we're praying before lordship my lord, adjournment for 2 weeks.
Which one?
Item 12, next matter.
Why adjournment?
Well, because I have to take instruction further because likely some developments is going to be happen in favor of the petitioner. That's why I am seeking 2 weeks time.
And may,
One day may be
may,
fixed.
may it be recorded that
But I am to receive instructions because I have received instructions today also to pray before your lordship on a 2 weeks adjournment. In the meantime,
What is the issue?
issue with regard to
Compassionate
compassionate appointment.
Oh, achha.
But maybe
If they come to your aid, why? What is your problem?
no, I don't have any problem.
so we are trying. We are trying, but since it is the management level, because we already prepared one policy and we sent to Delhi Steel Authority headquarters, head office. They are taking decisions.
All right, 12th December.
Very well, grateful. Grateful.
But, huh?
My lord, I had mentioned this matter yesterday, my lord, for praying for an adjournment.
No, I have. Yes, I have.
My
Here
lord,
for the state. Here for the state.
Yes, my lord. I was led by the Advocate General, my lord. Since he is not present, my lord, we need to have him prepared because this is whoever comes next as the Advocate General, my lord. This is a very heavy matter, so we will have to require a little time to get him ready. And
my lord, I am led by Mr. Guru Krishna Kumar, my lord. He is online, my lord. Learned.
Lord, I appear for the petitioner. I hope I am audible and visible, my lords.
Why you are not here before us?
Lords, some commitment in Delhi, my lords. I thought I'll take advantage of the online facility, my lords.
You also had a commitment to hear you.
In fact, it's not that Delhi is any exciting at this time of the year. My lords would have read in the papers. We are having the worst possible pollution at this time of the year. But we are bearing with it.
Calcutta is a better place than.
It is, my lord. It is no doubt about it. In fact, we are bearing that pollution and running in the corridors in Supreme Court.
Yes, madam, you agree what we will say. This is lingering for three benches were there.
And my lord, they have filed an application for addition of party. The reply has been served upon the legal AOR office at 1:30 p.m. today.
Yes, Monday it was 11:60, my lord. It was.
I have not received any copy.
Please,
Mr. Guru.
Yes, my lord.
Please agree to a date.
My lords, all right. I'm in my lord's hands, my lords. Whatever my lords consider appropriate, because I'm really in the
Subject to my lord's pleasure.
You're seeking addition of the
NCBC, National
NCBC.
We have filed National Council for Backward Classes as a party responded because, my lord, there is a newspaper reporting they are investigating
on the basis
affairs of the OBC list of the central list of the Bengal, my lord.
My lord, based on a newspaper article, I do not know how a application can be.
My lord, only that's why we are asking for a implement.
That's why we want, my lords, them to come in so that they give a response to the position.
It's not necessarily based on a newspaper article or its contents that we are concerned with.
Correct.
CBC's inputs would be vital for the purpose of fair appreciation of the facts, whether in your favor or their favor, who's our favor.
Hold on, my lords.
Nature of it is not a personal interest here that is being canvassed by any side.
My lord, but the the National Commission's has no, it is not does not have any regulatory powers over the.
That is the case, the statute prevents it anyway. So
My lord, it is now constitutional provision and after inclusion of 338B in 2018, my lord, 102nd Amendment.
Yes.
Yes, my lord.
It is a constitutional provision.
Yes, my lord, but the State Act is separate.
Madam, we are considering in our in your submissions on either side, we are considering the Maratha reservation, we are considering the Muslim reservation in Andhra Pradesh. We are also considering all other cases. So we take a larger pragmatic view in this matter. It should not prejudice anybody to have an independent body to give inputs to this court. Yes. What do you say? It should not really prejudice anybody.
I cannot disagree with that. My lord will not record my.
No.
In connection with the present petition, an application for addition of party being this one application you have filed.
3 applications in 3 matters, my lord.
You have filed 3 applications.
Yes, my lord. The 3 matters are there, my lord.
Can serve the 2.
GA1, Talu Guru Dao.
GS1,
Which are the 3 repeats?
One is 1160, my lord. One is 1160.
That is GA2.
That is J2, my lord. 1160 is J2.
And 578.
Then there is WP 60, my lords. And then 578.
In 578 and 60, it is GA1. Right.
Achha, in connection with the writ petitions being WPO 60 of 2011, WPO 1160 of 2013, and WPO 578 of 2012. Addition of party applications being GA such and such, such and such, respectively, have been filed. Heard Mr. Kumar, learned senior counsel, appearing for the. Oh, you are for the. He's for the writ petitioner in all.
No, 1160.
For the Nilratan Karmakar 22145 of 2010. Nilmadhav Karmakar 22145.
Application for the additional party.
No.
My lord, 1160, I am led by learned senior advocate Mr. Guru Krishna Kumar. In WPO 60, my lord, I am led by Mr. Lokhi Gupta, learned senior advocate. And in WPO 578, I am led by Mr. Shubhi Channel, learned senior advocate.
Heard the learned advocates appearing for the petitioners, and heard the learned advocates appearing for the writ petitioners and the state. Stop. The question of additional party is generally not one of initial jurisdiction of the court, but of judicial discretion, which has to be exercised.
My lord,
of the facts and circumstances of the case. Stop. The primary object is to bring before the court at one and at the same time the persons interested in the dispute, so that all the controversies may be finally determined once and for all, and in presence of all parties without delay or inconvenience. Stop. In view thereof, we are of the opinion that the presence of the National Commission for Backward Classes would be necessary for adjudication of the list. Stop. Accordingly, the addition of party applications being such and such are allowed. The respective learned advocates on record of the writ petitioners in the three writ petitions would be at liberty to make necessary correction in the cause title of the respective writ petitions. Stop. The copies of all the writ petitions shall be served upon the added respondent. The petitioners are directed to serve all pleadings upon the added respondent, and to file an affidavit of service on the returnable date. Stop. Please the matter for further consideration.
6 weeks, my lord.
You agree to a date and tell us.
After vacation, my lord.
No, my lord.
My lord, let us conclude our part of hearing, my lord.
After joining the
further consideration on such and such as fixed at 2 p.m. Stop. In the meantime, the added respondent would be at liberty to file affidavits in opposition in the respective writ petitions. in the meantime, stop. The added respondent is directed to file its affidavits in opposition in the respective writ. The added respondent would be at liberty to file an affidavit on prior service upon the respective upon all parties in the meantime.
Very well. And on the next date, my lord, subject to my lord's convenience, I was going to request, I am really in the middle of my I'm really in the middle of my submissions, my lords. I was requesting, subject to my lord's convenience, could it be sometime in December, my lords, so that I'll be able to, next couple of weeks, my lords, so that I can conclude my submissions, my lords.
My lord, I'm praying for a little more time because whoever comes will.
No,
আরেকটা লাইন ওখানে লিখে দেবেন এই অর্ডারটা তো ও বলেছো তো ওই all pleadings service of all pleadings along with this order all
Because
pleadings
my-
along with a copy this the matter for further consideration in the daily on
My lord, the added respondent, whatever they submit, we will want to give our reply to that also.
Therefore, taking into account all of that, my lords, making provision for all of that, I was going to request.
My lord, we require a little time for that.
No, because at the end of the day, my lords, we'll have to complete our submissions.
Yes, my lord.
Come, let us hear the matter. If
Correct.
it,
My lord.
necessarily it is going on. If after getting the affidavit you want to say something, you come to us and say.
My lord.
We want to finish.
My lord, one more thing, my lord. Will my lord be pleased to record in the order that my submissions, that is, they are not a necessary party, those usual, my lord.
Hard deal
And
state opposes the prayer for addition of party.
Please appreciate this. This is dragging. I mean, it's dragging.
My
from
lord.
4 different benches.
10 years. Absolutely. Absolutely.
To this.
My lord.
Whichever way. Whichever way. So my request, our request to both sides, please cooperate and finish it off.
My lord.
Whichever way.
Bow down, my lords, I bow down.
My petition for last 13 years, 37 times already heard the by honorable division bench.
I was going to request, my lords, sometime in the second week of December, subject to my lord's convenience, my lords, subject to my lord's convenience.
May I request after
any pleadings in the meantime, change the pleadings in the meantime. File an affidavit or whatever, then replies. All pleadings will be completed.
ওই লাইনটা কি বললেন? and the other parties would also be at liberty to file their affidavits in reply. So, 9th January.
My lord. Obliged, my lord.
On 9th January as fixed at 2 p.m.
Lords, can it be subject to my lord's convenience? Can it be in December, my lords? Even towards the third week or something, my lords.
It's not a regular bench. Vacation would again intervene. So
I understand, my lords. I understand. Can it be the second week or third week, my lords? It's my earnest request, my lords.
Council, the problem is there is a affidavit likely to come, then there will be replies. So we'll be sitting in futile, just with leaving our regular benches.
No, I fully understand, my lords, what is falling from the court. I was only wondering, my lords are giving about a week or two to the NCBC. So once that affidavit comes, we should be able to quickly go on with the matter, my lords. I would request that it can be in December. If it's still, my lords, is not possible, then anyway subsequent date can be given, my lords. In the same vein as what my lords had indicated, my lords, to the States Council also.
Mr. Council, let us keep 9th January as peremptory, and we will expect all parties to
Be ready, my lord.
continuously make
My lord.
submissions. We will
Very well, my lords. Very well. Very well. Very
My
well. I understand.
My lord, this peremptory order may be recorded, my lord. 9th peremptory direction, my lord, may be recorded, my lord, for hearing.
Here, sir. We have said.
Third, as madam,
My lord.
please inform your advocate general, whoever it is,
My
make it
lord.
ready. In the meantime, you have sufficient time.
Once we have an advocate general, my lord.
Whoever it is, then
My lord.
we can't stop functioning because
My
of
lord.
the absence of an
My
advocate.
lord.
Please
My lord, otherwise I will
make
do
it
my
very clear to you. You are ready. Mr. Mukherjee is there. Please start.
My lord, may we file our replies to those GA applications, which is allowed? The reply, my lord.
Let the evidence filed by the respective parties be kept উপরে দিয়ে দেবেন ওই hard
Opposition দেয়নি?
Just take it up.
Opposition file হয়নি? My lord, I will have it filed in court. The opposition apparently, the court of the affidavit in opposition, it is ready, I don't know why it has not been filed. He just.
You check up and file, give it to our.
Fine.
File করলে নিয়ে নাও।
Before your lordship, I just may I have your lordship time indulgence?
This bench.
Your lordship, but original statement.
I am obliged, my lords, deeply obliged.
কি অবস্থা
কিছু ওইটা একটু চেক করে নাম্বার গুলো বলে দিও না, জিএ তো সবকটাই জিএ।
No, this is my application. Ma'am. The respondent, a helper in railway, my lord, applied for selection by promotion from group D to C. From group D to C, and for that, my lord, there is a written examination, and then, my lord, there is a interview. Now interview, in place of interview, the record, the scrutiny of the record. That is divided in two parts. 100 marks. Out of 100 marks, 85 marks, my lord, allotted for written examination, and 15 marks, my lord, for the scrutiny of records. Here, my lord.
Just give us 2 minutes.
My lord.
Who is for the respondent?
Yes, ma'am.
You're there, Mr. So what benefit tribunal gave you?
That
Tribunal, what did tribunal say?
Lord, set aside the order of cancellation.
Lord,
But the material clerk post has already been abolished by the railway.
No. We are wanting to know, we are understanding. There was a selection process from group D to group C.
Milord.
Promotion process.
Milord, by promotion.
Examination was conducted. 23 persons participated.
No, my lord.
28.
28 persons
qualified. Very good.
My lord.
They underwent the second stage of the recruitment process.
That was not done. That was not done, and before
ultimately nobody was appointed. Ultimately appointment was given.
Ultimately, my lord, out of 19 vacancies, 21 were selected. Then, my lord, thereafter, my lord, written examination was cancelled. Then, my lord, written examination cancelled, and that was made impugned before the Central Administrative Tribunal. And thereafter, my lord, this material clerk post, my lord, this was, my lord, merged with the junior clerk.
Why don't you place the order impugned? Then we can come to learn about the facts.
My lord. Here it is said the arbitrariness. There is no arbitrariness, my lord. Yes. My lord, this is at last of my petition, my lord. That is the order.
Set aside the cancellation.
But
what benefit he can get now? He has already retired.
He has already retired. My lord, 22nd January 2022, the tribunal passed final order. And my lord said the second part of the process should be completed within 2 months. My lord, that is by 9th of March 2022. And this person, my lord, retired sometime in February 2022, before the this expiry of the
From
period.
Group D post.
Yes.
From Group D post.
From Group D post.
Then what benefit if the order is not touched?
Milord.
If the tribunal order, if we dismiss your writ petition, suppose we dismiss your writ petition, what benefit you will give him?
Nothing.
He has already retired.
He already retired. He already retired.
So has he made any prayer for any lump sum compensation or anything?
No such prayer is there, Milord. Kindly have a look, Milord, that the petition before the original
How
petition.
can we help you?
Milord.
We will come back to you. Just don't tell us. Just answer our query.
After 3 years, they have cancelled the selection.
Tribunal has cancelled.
They have cancelled the selection process after
That has
3
been
years.
struck down.
After 3 years. But throughout the career, I was holding the post of Group D. That was the first and last opportunity to appeal the selection process from Group D to Group C.
Were you promoted?
I did not get promotion because they have cancelled the selection
No,
process.
they cancelled 3 years thereafter.
After 3 years, when I was in the service.
That was at that time you were in Group D.
Group D, and I was in the service.
You were promoted by that selection process. Were you promoted?
If the selection process is restored, cancels are already set aside, then automatically I get promotion. And my repatriation of pension will be made by taking to consider the post of Group C. That benefit to get that benefit, they have done like this. No reason has been assigned. No reason.
No. Your selection was in the year, which year? Your selection was in which year?
3 years before retirement.
That is, you retired when?
I have retired from service.
Retired in January 2023.
2023.
Very good.
Milord retired on 28 February 2022. 28 February 2022.
Gets sold at 1 month.
And when the selection took place,
Selection took place in the year 2019.
2019. Therefore,
when was the tribunal order?
Tribunal has passed this order on
21st
10
January 2022.
So that is prior to your retirement.
Prior to my retirement.
So what did the tribunal say? Give promotion?
No.
2 months.
Cancellation set
Process
aside.
to be completed within 2 months.
Tribunal
Second part of this Milord part be completed within 2 months. Kindly have a look at that.
They have not complied with this order. When I was
The last line of the order.
Mr. Das, let us be practical. Suppose your tribunal order was 10th of January 2022. Tribunal set aside that cancellation and directed to finalize the selection
Appropriate
process
order within 2 months.
and fill up the 19 vacancies within 2 months. In the meantime, you retired.
After when tribunal order was passed, I was in the service.
Yes, you were in service.
Now they did not comply with the tribunal, so they approached for a lawsuit. That is why.
No. You should have pointed out to the tribunal that why 2 months? Give me the benefit today, otherwise everything goes.
Well, actually, some time has to be given to the respondent to complete the
That
process.
you ought to have argued, Mr. Das. Today, if we uphold this order also.
Just 2 months time tribunal has given. Reasonable time has been.
Today, suppose we dismiss their writ petition. What benefit you will get?
That is why there is a decision on that part. I shall say.
But
there is a decision of that.
That is not your. You have not challenged the tribunal order. You are satisfied, all right, 2 months time you take, I will retire. You have retired, doors are closed. What you will get?
Some of the, even after retirement, the Supreme Court has said.
That you can urge in your independent challenge to this order. You could have challenged that portion of the order that don't make it 2 months, I will retire. You immediately give me the benefit.
Normally, when the court has passed this order, 1 month or 2 months is a reasonable time has been given by the Honorable Court to process the complete. Only record of service knowledge.
Mr. Das, this order is infructuous for him because tribunal said finalize the selection process within 2 months. Now, by the time they finalize giving promotion to you,
I will get repatriation of pension.
after cessation of your relationship.
That is the decision on that point.
Oh, decision you show. If you have challenged that, we could have said.
One challenge. I got the order from this court. They have cancelled selection after 4 years from the date of conducting.
All right, we will not say anything about your outcome. We will dismiss the writ petition.
And subsequent cause of action, I shall file again original application. That the Honorable High Court has upheld this order. So whatever consequences and benefit, kindly give it.
My lord, have a look, my lord. At
The
the prayer.
problem is this one throughout the career, my lord. This is the first and last opportunity.
This you are doing for your own mistake. Your advocate in the tribunal did not ask this. Had you were there, you were নিজে থাকলে এক্ষুনি হয়ে যেত। You should have told the tribunal that you have passed an order in my favor. What will be the fate of that order if my employee relationship ceases in the meantime? That is why Supreme Court ordered your saying. What Supreme Court ordered your place? What Supreme Court ordered?
There is a, although it's a case of ACP and MSC, Obhijit goes to the case. Para 9 and 10 was very.
What has the Supreme Court said?
I am submitting. Since the applicant has retired from service, we make it clear that he is not able to pay or allowance for the period for which he had not worked in higher administrative grade officer. But his retrospective promotion from such and such shall be considered for the benefit of repatriation of his pension. For the benefit of, I am not.
How can that be done after your retirement?
Benefit of, this person also retired.
That is pay fixation, Mr. You are changing the nomenclature of the post. Anyway,
You lord, kindly have page 30. Under the prayers.
Then what you have done after the tribunal order, you have not taken any step.
I have preferred, my lord, the application before this court.
Yes, come to the tribunal's order. So, Mr. Drolia, you
only arbitrariness. But there is no arbitrariness.
No, why don't you give him pension? Why don't you give him pension in Group C post?
Yes, that is the.
What will be the problem?
My lord, here, my lord, the cancellation was made as per rules. As per rules, there is a vigilance report, and the Central Administrative Tribunal said arbitrary. The order of this my lord railway was arbitrary without any reason, and reason has been given.
Show us.
My lord, here, my lord, the judgment which my learned friend relied on, that speaks about the reasonableness and the arbitrariness. In that case, it was arbitrarily, my lord, cancelled. There was the, my lord, appointment of the typist, and the written examination was cancelled for typist. My lord, then, my lord, one of these successful, my lord, candidate, my lord, that applied before this, my lord, the tribunal for confirmation of, my lord, his appointment, my lord. Then, my lord, there it said, my lord, if the cancellation is arbitrary, then the process will be set aside. Will kindly have a look, my lord, that judgment, my lord.
A judgment will come later. Show us what is the wrong in this order.
Yes. My lord, here, at the last.
So no other application was filed by the successful candidates?
No other application filed. You know what happened, my lord? Subsequently, there was another, my lord, selection process, and there was another written examination. All those participated in the earlier written examination, my lord, all participated, all have been promoted.
All participated?
All participated.
Including the petitioner?
Petitioner did not. Petitioner did not, and petitioner challenged that cancellation of the, my lord, this written examination. Only petitioner challenged. But all other, my lord, participated, and they have been absorbed. And they promoted Group C.
So all those 19 vacancies?
Yes, 18 have been completed. 18 person who were there, out of 28, my lord, out of 28, my lord, mostly all have been absorbed. Against,
Mostly will not help. You have to give us the specific figure.
my lord, kindly have a look, my lord. Kindly have a look in my affidavit in reply. Affidavit in reply, 8 page 41. This is the latest, my lord, received from the railway in the matter. My lord, here, this is addressed to me, my lord, then as desired by, has your lordship got it?
Yes, yes.
As desired by you during the telephonic conversation on 14/7/2023, the present service status of the staff who were declared qualified in the written examination, while this office letter number such and such dated 19th September 2013 is attached as Annexure A. It is revealed that almost all the staff have been promoted to the higher post during this tenure, and nobody was the party of the OA number 350/1641/2.
What is his name? His name is Ranojit Dotto.
Yes.
Eh?
Ranojit Dotto.
Where is his name in the list? He was not successful.
Yes. He was successful. But my lord,
His
accept
name
him.
his name is not there in the list. This page 42.
He is not participating.
Yes, my lord. 12.
12.
12.
So there was a fresh selection process thereafter.
Yes, because my lord, the material clerk merged in junior clerk, and there were 142 vacancies. So there were combined written examination. And all participated, which earlier participated in the earlier written examination, all have been accommodated. But the petitioner did not participate in 2019. Earlier was in 2013, but in 2019, it was the second examination held, my lord. And then, my lord, all have been absorbed, and cancellation was made in 2016. And in 2006,
why didn't you make a list of dates? First selection process, when was the written test? In the first selection process, 15th of September 2013.
my lord.
Result was on 19th September 2013.
My lord.
And thereafter there was a vigilance.
There was vigilance, and he was called by the vigilance.
Let us understand. There was a written test. Thereafter there was interview provision.
There was that scrutiny of record, because interview was there, but it has been modified. Now it has been made.
In the earlier selection, was there any in the earlier selection process which was cancelled? What was the selection process? Written test and interview.
Interview. But my lord, there is a one document produced, that is the 2003, where it is said that via was now substituted by the scrutiny of record that they have produced. The railway, by a circular, said that the interview via was will be substituted by scrutiny of record. They have produced the one record in 2003. That is marked 15 marks. That is the second part of the selection process.
Today, Mr. Drolia, if we allow your petition, suppose today we dismiss your writ petition, how will you comply with the order? This order, to comply with this order, you have to bring back all the persons who have already been selected and appointed.
Yes, that has been already promoted. They have already absorbed. Merely the petitioner has challenged this order before the Central Administrative Tribunal, and that has been now allowed and directing to complete the process within 2 months, but before the expiry of 2 months, he has already retired. And my lord, kindly have a look.
Yes, show us what is the wrong in the order.
Wrong in the order is, my lord, the order speaks about, my lord, that this is the arbitrary. There is arbitrariness. And The judgment which are recorded here, my lord, those dealing with where there is arbitrariness.
No, where is the cancellation order? The order which was challenged in the OA.
Yes,
Second
that is
page
that
of the
page.
order, it has been pasted by the diamond. Second page of the order, paragraph 2.
Oh, acha.
No reason has been asked.
Challenging this cancellation, you preferred original application. After 3 years. Original application was 2016.
2016 I applied.
They have cancelled.
Yes, Mr. Dole. Yes, continue.
My lord, kindly have a look, my lord. Here, my lord, the learned tribunal has narrated, my lord, the part of the judgment. The part of the judgment where it said, where there is arbitrariness, then the court can set aside. But here, my lord, in the instant case, there is no arbitrariness.
Show us that. Show us.
Yes, my lord. Here, my lord, after, my lord, the written examination was completed, and, my lord, the result was declared, my lord. Then, my lord, the railway received complaint. My lord, some irregularities in the conducting the written examination. On the basis of that, my lord, the matter was referred to vigilance. And the vigilance, my lord, made thorough inquiry. And after thorough inquiry, my lord, the vigilance has filed a report. And that report was sent before the Central Administrative Tribunal. So now the Central Administrative Tribunal has said no record has been forwarded. There is no record to say that there is a.
Where is that?
Yes, my lord. Kindly have a look, my lord. The in judgment, my lord. That is the
internal page.
Internal page, my lord.
6.
8.
Internal page 6, first paragraph.
My lord.
From the note as above, nothing in regard to the nature of complaints received or details of irregularities complaint has come to the fore to justify cancellation. That's very good.
So this judgment, my lord, here there was arbitrariness.
Next, paragraph 8. No records have been placed to demonstrate the nature of irregularities.
Yes. No
Now,
records
so
have been
we
placed.
directed you to produce the vigilance report.
My lord.
We directed you.
Yes.
Where is that report you have filed? Yes, you have given us copy.
My lord. Here kindly have a look, my lord. What were the irregularities? That is, my lord.
You have given a copy to him.
Yes, my lord, I have.
Acha, did you annex this in your opposition?
Well, I have not. I have not, my lord, because it was a confidential report. Therefore, I did not. Subsequently, my lord,
You
with
have
order of the
give
court.
another copy to my learned brother.
Yes.
Where is another copy?
Have you got? Yes.
Give it to my brother. You have a copy.
It must be no, my lord. It must be 2 copies, my lord. It was filed 2 copies.
No,
in the record.
one copy. One copy. Surajit, show us, we will share which portion you are pointing out. Okay?
My lord, I have taken, my lord.
Xerox করার এখানে permission আছে? দেখি আমার. You have copy? আচ্ছা,
My lord,
please.
My lord,
where you have said Mr. Drolia?
My lord, 2.18. I'm not reading entire, my lord. 2.18 of the report. 2.18.
So why didn't you place this before the tribunal?
This was
report was placed.
Yes.
No. Tribunal says no records have been placed.
But that originally lying with the tribunal. Original of this report lying with the tribunal. This is the copies.
Tribunal directed that report to be filed.
But I am told by the.
Don't say something which you do not know. Are you sure it was before the tribunal?
It has been.
If that was there before the tribunal, why did the tribunal say that no records have been placed to demonstrate the nature of irregularities?
My lord, I have
Your
instruction.
counsel was there. It
Yes.
was not an ex
And
parte order.
this is also recorded in the order of this in this honorable court. My lord, kindly have a look in 21st December 2022 order. Justice Tandon order, my lord. Here it is recorded, my lord.
Yes, what recorded?
My lord, it is recorded. The order of cancellation was subject matter of the challenge before the tribunal. By the impugned order, the tribunal set aside the order of cancellation on the ground of absence of proper reasons, despite having on occasion to go through the vigilance report submitted by the petitioner authority, and that after the cancellation of the said selection process, fresh selection process was initiated and the candidate participated therein. Thereafter, the successful candidates have already been promoted to Group C post. So here, already that vigilance report was filed and considered. This is recorded in the order.
Yes, what you are which portion you are
My lord.
showing us?
Yes, my lord. My lord, I am referring, my lord. I am referring to, my lord, page 2.18. Without going in the detail, my lord, I am referring, my lord, some irregularities, my lord. Even there is one irregularity, my lord, it can be cancelled. That empowered to the general manager under the, my lord, the circular of the railway board. That is the, my lord, that subordinate legislation, my lord. The following types of irregularities have been detected, namely setting of question paper of a very high standard, not commensurate the ability of a Group D employee. Secondly, general candidates who got 60% marks in written paper were treated as passed, while the extant rule says 50% marks as pass marks. Thirdly, reserved candidates who got 20 and more but less than 51 were treated as passed, while the rule mandates the pass marks of 40%. Fourthly, several inconsistencies were noticed in awarding marks in case of two candidates, namely Munukoti Indurani and G. Paparao, who managed to scrape through. The above irregularities are disclosed under the heading discussion. The aspects that have come out from the above investigation are following and discussed in the subsequent paragraph. Setting a higher standard of question paper, fixing of wrong pass mark, violating let down provision in establishment serial number such and such, as a result of which 8 general candidates were left out. Fixing wrong pass mark for reserved candidates, as a result of which a large number of candidates were treated as passed. Violation of provision contained in para such and such. Improper evaluation of answer sheet in case of two candidates, violation of provision of establishment serial number such and such, and not informing the examinee.
Julia, kindly. In respect of 2.18, general candidates who got 60% mark in written paper
My
were
lord.
treated as passed,
My lord.
while the rule provides 50% as pass mark.
My lord. Here, my lord, the rule provides that 50% marks if obtained, he will be declared passed.
Now, paragraph 3, second bullet point, fixing of wrong pass mark, violating the provision of Sajna, as a result of which 8 candidates were left out.
My lord.
They secured more than 50.
Yes, they should have been declared passed, but they could not. Because if the 50% is the cutoff, then they will be declared passed. Here it is 60%. Rule says 50%. But here, arbitrarily or
so the question paper was very hard, very difficult.
Question paper was very hard, and in the last, my lord, kindly you, my lord, in the last it is stated also by the my lord, 5 conclusion, my lord. Five 5.1, Sri Ajay Ranjan. Has your lordship got it? 5.1, conclusion, my lord. Later part of the report, my lord. last but one.
Yes.
Conclusion. 5.1. Sri Ajay Ranjan is responsible for setting a difficult question paper which is impracticable for a Group D railway servant of average intelligence and normal standard of efficiency to answer and qualify in the test establishment such and such. Although Sri Ajay Ranjan claimed during clarification that the question were in line with NCERT class 10 standard, it is clearly evident that the question were very high standard for any Group D employee who are generally non-matriculate of normal intelligence to answer. In fact, certain questions can only be answered by the candidates who are well acquainted with the international affairs or have sufficiently high degree of knowledge in biology, IT application, trigonometry, and definitely such type of question cannot be said to be having a practical bias to the area of working of the examinees. Neither is it expected to a non-matriculate to answer such difficult question. Therefore, by setting such difficult question paper, Sri Ajay Ranjan is responsible for violating the provision of such and such, and he is also responsible for not bringing the statutory provision relating to the objective type question as contained in such and such establishment such to the notice of the examinees by printing the same in the question paper. Further, since all candidates who should have passed as per the relaxed standard were placed in the next lower categories, best among the failed candidates.
What does it mean?
Further, since all candidates who should have been passed as per the relaxed means, my lord,
so in between 40 to 50, they were kept as best amongst the failed candidates.
my lord,
Though they would have come within the zone of consideration.
my lord. So my lord, that these reserved candidates, my lord, they should have obtained 40% marks for pass mark. But here said, even if 20% marks obtained, my lord, they will be declared pass. So this is against the rule. And there, my lord, it the cutoff marks 60%. There, my lord, it was 50% as per the rule. So they made 60%. So those who got the marks, my lord, in between the 50 to 60%, my lord, those were declared failed. So looking all these aspects, my lord, my lord.
Finally come to clause 3.8. Fixing of wrong pass mark wrongly taken as C instead of 15 unreserved. Should be from non-safety category for general as known as
fixing of wrong pass mark wrongly taken as 60% instead of 50% in unreserved category. The pass mark as adopted and as it should be for LDC from Group D to Group C in non-safety cadre for general category candidate is shown below. Category general, erroneous pass marks 60%. Here, my lord, total marks was 85, my lord. Therefore, it is 51, my lord. That is the and my lord, 51 is the, my lord, 60% marks of the 85. And
so,
correct.
So Ranojit Dotto was in that list.
Yes, he qualified there. He passed the examination. There is no doubt.
He got Ranojit got 67.5.
Yes, got.
Now, where is the very good? Where is the advertisement? Where is the advertisement for filling up this post?
Advertisement.
So your contention is the cutoff mark was set at a higher level.
Yes.
As such, the petitioner and as
some
such,
of the candidates did not pass, and likely, my lord, similarly, my lord, then for reserved category, it was cutoff marks 40, and they have treated 20 and never passed. So many others who were not to be passed, they were declared passed.
তো রণজিৎ পেয়ে গেছিল 67। না না সেটাই তো জিজ্ঞেস করছি ওকে। ও বলছে যে পরের পরের পোর্শনে ইন্টারভিউ ছিল, তো পারছিল রিটেন টেস্ট এবং রিটেন টেস্টে 50 জন বেরোলো। কাট অফটা যদি নিচু করতো তাহলে 70 জন বেরোতো। তো বক্তব্য সেটা। যাই হোক, হোয়াট এভার দিস ওয়াজ ডেফিনেটলি কনসিডার হয়েছে ট্রাইব্যুনাল তো সেই বক্তব্য কিছু বলবে ক্রিটিসাইজ করে চেঞ্জ সার্কার।
Page Milord 38.
Where is your cancellation order?
Cancellation order, Milord.
That has been quoted in the order.
That
What you are showing us now?
Milord, I am showing, Milord, before your lordship, the judgment which my learned friend relied that the cancellation is wrong.
These issues that there were 19 vacancies.
Milord.
All of them, others have already filled up. Most of them have taken up and filled up the post. Where do we get these facts?
Milord, this fact, Milord, I have made on affidavit, Milord. That is my affidavit in reply. I have annexed a document from the railway. At page
42, how
41.
many?
At 41, I have stated, Milord, and then it is
41 is your instruction. There were 19 vacancies.
19 vacancy.
Now, these 19 vacancies, you written test, was any fresh advertisement made?
Certainly, Milord. If there is subsequently, there is the another process, Milord. There must, because there vacancies of the junior clerks also clubbed. Milord, these material clerks must.
We will find that pleading of yours. Where you have told the story? Where is that story?
Yes, Milord. That I have stated, Milord, in this affidavit itself.
Yes, show us that.
Milord. Milord. Milord, kindly have a look, Milord. Paragraph 2 at page 2 of my affidavit in reply on behalf of the petitioners. Milord, here the respondent was working as helper under Assistant Material Manager, Southeastern Railway, Kharagpur. Petitioner number 3 herein and had applied for promotion to the post of material clerk in reply to the notification dated 20th June 2013 of the Deputy Chief Material Manager, Kharagpur. The petitioner number 2 herein, wherein it was advised to submit the application from all Group D staff for appearing in the selection process against 19 vacancies of the material clerk in Group C. The process of selection consisted written test and scrutiny of service record. Working report of total 100 marks, 85 marks was fixed for written test and 15 marks fixed for scrutiny of service record and working report. The respondent had appeared in written examination on 15/9/2013 and was qualified in the written examination along with 27 other candidates. The result of the written examination was published on 19/9/2013. After publication of the result of written examination, the petitioner had received some complaints in conducting the written examination, which was investigated by the Vigilance Department of the South Eastern Railway. In the course of the investigation, the Vigilance Department had seized all the papers related to the said written examination, and after an investigation inquiry found several irregularities in various stages in the process of conducting written examination. For examination, irregularity in setting of question paper, evaluation of answer script, fixing of qualifying marks, and preparation of the panel, etc. I crave leave to refer a duly attested copy of the final investigation report of the Vigilance Branch of the South Eastern Railway at the time of hearing, if necessary. The petitioner number 1, on the basis of the said report of the Vigilance Department and the recommendation of the Senior Deputy General Manager of South Eastern Railway, had cancelled the said written examination in accordance with the provisions contained in Circular number 47/2019 of the Establishment Serial Circular 2019 and Railway Board letter number such and such, dated 17th February 2019. A xerox copy of the said circular number such and such has been annexed at page 5 of the pages 61 of 63 of the petition. The said cancellation of written examination by the petitioner number 1 was duly communicated by the Senior Deputy General Manager, South Eastern Railway, Garden Reach Road, by its letter dated 18/25 January 2016 to the Controller of Store, South Eastern Railway, Garden Reach Road, Kolkata. A xerox copy of the said letter dated 18/25 January 2016 has been annexed at page 1 at page 17 of the petition. The petitioner number 3 thereafter by a letter dated 5/4/2016 duly notified the order of the petitioner number 1 in respect of the cancellation of the written examination. A xerox copy of the said letter dated such and such has been annexed at page 2 at page 18. P2 at page 18 of the petition. The respondent applicant has filed the OA being 350/1640/2016 before the Learned Central Administrative Tribunal, Kolkata Bench, Kolkata, against the said impugned letter dated 5/4/2016 of the petition number 3, notifying the cancellation of the said written examination. The respondent have filed its reply to the said original application of the applicant. Subsequently, Railway abolished the post of the material clerk and merged with the post of junior clerk cum typist on the same pay band, and keeping the 19 vacancy intact as the case was under sub judice. After merger of the said post of material clerk with the post of junior clerk cum typist group C in the same pay band, the Railway issued a notification on 9/3/2019 for selection of 141 vacancies, which was held up for the last 16 years. As such, selection process was initiated for promotion from Group D to Group C, keeping aside 19 vacancies which were subject to earlier selection process and being sub judice before the Learned Tribunal. The respondent applicant
So those 19 vacancies were kept aside.
Kept aside.
So in those 19 vacancies, they did not compete. That after the merger, fresh notification that was made, 141 vacancies.
Milord.
Over and above that, there were 19 vacancies.
Those 19 vacancies kept aside because this was sub judice.
Because the tribunal application was pending.
Because tribunal application was pending, therefore 19 vacancy kept aside, and since the railway work was hampered, therefore there were a lot of vacancies. So therefore 141 vacancies were to be filled, and they notified them for written examination. And there all other who participated in the earlier written examination participated, and they have been promoted. But petitioner did not. The respondent did not participate.
Where have you stated that respondent did not participate? Now read the next para. Respondent filed a miscellaneous application in the
Here,
OA.
the respondent filed a miscellaneous application being MA number 350/541 of 2019 in OA number such and such for stay of the said notification.
Where is that?
Instead of participating in this second process, this respondent filed a miscellaneous application in this pending application before the Central Administrative Tribunal for stay of that notification. and that was dismissed.
Where is that order? Dismissed.
Yes, that miscellaneous application dismissed and notification because they challenged the further notification.
Please show the order. Is it folder?
Do you have the order of dismissal?
Milord, here, Milord, if Milord this miscellaneous application filed challenging the further notification, and Milord that was contested, and railway will not do Milord anything unless there is an order, Milord. That order, Milord, I am not having right now, Milord, but there is an order. That's why the railway proceeded. And kindly have a look, Milord, the prayer. What the prayer they have made in original application. And they cannot go beyond the prayer.
What is the prayer?
Prayer, Milord.
Where have you, first go one by one. This application was dismissed. Where you have stated that? In your reply, you have said that?
Yes, Milord.
Art 2 is the latest status. He was the latest.
By the letter dated 14/7/2023, the petitioner number 3, Railway by Council provided latest status of the case. A Xerox copy of the said letter is annexed here too and marked as R2. Now, Milord, I have dealt with, Milord, the
Where is
opposition.
that status?
Status, Milord, that is at page, Milord, 8.
That
page
was dismissed
41.
on 40?
41, Milord, R2.
No. That miscellaneous application was dismissed.
Application miscellaneous application dismissed হয়ে গেছিল তো মানে হ্যাঁ এমএ ডিসমিস হয়েছিল অর্ডার আছে Milord, unless there was a dismissal order, railway will not proceed.
Why you make this
Milord,
sort of submission?
presumption, Milord.
You got time, you did not take, obtain the material, the actual instruction. Where is this letter of 24th of July 2023? Where have you annexed it?
24th of July 2023, Milord, is, Milord, at page 41.
41.
41 of my affidavit.
We don't find that miscellaneous application was dismissed. However, in the final order, there is no recording of the miscellaneous application. 10th of January 2022. All right. This is your case.
Milord.
So, according to you, there was no arbitrariness or unreasonability?
Milord, that kindly have a look, Milord. That I wanted to place before Lordship. That is their reliance of that judgment. And
Show us.
that is, Milord, 8 page, Milord. Page 38, Milord. They are relying on, and the tribunal also relied on this. This is, Milord, the judgment reported in 2010 two Supreme Court cases 483. Here, Milord, I'm coming to the, Milord, para 1 without the head note, Milord, judgment. That is, Milord, page 41. Milord, may I read, Milord?
Page 41.
Page 41. Milord, page 41 is the judgment part, Milord. Here, Milord, here's similar facts, Milord. That's why I'm here, Milord. There was arbitrariness. That's why Milord, it was set aside by the High Court. But here there is no arbitrariness. Here there is a vigilance report. Vigilance report was considered. And then, Milord, here there was nothing. And it was set aside. Here, Milord, may I read the, Milord, some paragraph, Milord. The leave granted. These appeals arise out of the order passed by High Court of Andhra Pradesh at Hyderabad, wherein by the read petition number such and such has been allowed, and the order passed by the Central Administrative Tribunal in such and such set aside. Milord, paragraph 2. The Senior Divisional Personnel Officer, East Coast Railway, Visakhapatnam, issued a notification proposing to conduct a written practical typewriting test for filling up of the vacant post of the chief typist in the pay scale of rupees such and such. As many as 20 candidates appeared in the test held on such and such date. The result whereof was announced on 22nd November 2016. Some of the candidates who
Show us the
failed.
relevant portion. Show us the relevant portion. Who
Here-
failed to qualify made a representation.
Here, my lord, here, my lord, the
Paragraph 7.
then, my lord, some this, my lord, the participated in the this typewriting test, my lord. There they alleged that typewriting machines were not good, and my lord, the my lord, officer concerned, my lord, set aside the written examination without making any note.
Where is that paragraph?
My lord, yes, my lord. Some of the candidates who failed to qualify made a representation complaining about the manner which the test was conducted, alleging that defective typewriting machines provided to them placed them at a disadvantage, which candidates declared successful. The successful candidates also appeared to have made a representation before impressing upon the authority to go ahead with the interview and to complete the selection process expeditiously. Since that did not happen, and then, my lord, in the meantime, divisional manager of the appellant railway issued an order on 14th 12 2016 cancelling the typewriting test conducted on 30th October 2006 by another notification of event date. A fresh night typewriting test was notified to be held on such and such date, and all the 12 in-service candidates who had appeared in the earlier test by an interim order passed by the tribunal, the railway authority were allowed to conduct the proposed second test, in which applicant, therefore, the applicant before the tribunal could also appear. The applicant was at the same time permitted to amend the prayer. So here, my lord, one successful candidate made a application before the Central Administrative Tribunal that he should be declared successful and second part should be completed. And that cancellation is bad. My lord, here, my lord, because there is arbitrariness, no reason has been provided. On the basis of that, my lord, High Court said, my lord, that yes, there is no reason provided for cancellation. So therefore, my lord, in those circumstances, my lord, it was treated that there is a fit case was set aside because there is a arbitrariness without reason.
Anything else?
And here, my lord, the arbitrary has been, my lord, para 19, my lord, of the page 44. Black's Law Dictionary described the term arbitrary in the following: arbitrary depending on the individual discretion, specific determined by a judge rather than by a fixed rule, procedure or law. Here, my lord, there is no arbitrariness because they,
মিসেলেনিয়াস অ্যাপ্লিকেশন গুলো স্টে করতে সেটার কানেকশনে যদি স্টে ও বলছে অর্ডার আছে, ও বলছে অর্ডারটা প্রডিউস অর্ডারটা একটা হয়েছে না হয়তো অরিজিনাল নাম্বারটা এই অর্ডারটা
But the internal page 5 of the Cabinet order. Here, the landed page regularly again saying, hunting post has been filled up, election process has been conducted. Each paragraph is very important, my lord.
Paragraph?
From top, my lord, I am reading.
Which paragraph?
Internal page 5 from top.
Internal page 5. Yes.
The detailed guidelines contained in the report's letter, number 35 2009. The recommendation by GMACR has been followed. In cancel the state selection for the 19th post of material clerk in payment of such and such, and cancellation was issued by the official of the so read with original moderated so. Vigilance investigation took place in this case, resulting into the submission of the report, and cancellation of the state exam was issued due to certain individual and as approved by the competent authority. They have admitted that there are large number of vacancies in junior clerk. Presently, 141 numbers. Categories and promotion of staff could not materialize during 16 years, which are very demoralizing effects on staff and also very suffocating. The working of the entire organization have thus been very much affected significantly. In exchange of the service, the selection was initiated, keeping aside 19 posts, which was subjected in earlier selection subject before the selection. Now, Lordship, can you see, my learned friend could not demonstrate before your Lordships what is the actual reason the vigilance has cancelled my selection. What is the duty of the vigilance department? If there is a leakage of question paper, if there is a leakage of question paper or manipulation or grabbing nepotism is there, in that event the vigilance can interfere in the for cancelling the selection process. The vigilance case is murder. Vigilance cannot say the question paper is hard, so and so. This is the administration will take the note in respect of that. This is not the lookout of the vigilance department. If you lordship see the vigilance report, the vigilance report at paragraph 2.16, my learned friend did not read up. Paragraph 2.16, my.
Para
2.16, vigilance report. Here, they have assessed the marks which is 67.5.
yes, you got higher marks.
I got the higher marks. Now, what is the reason for cancellation, Malad? They have stated.
Vigilance report is not under challenge.
I am not challenging. I am not saying anything. Vigilance.
Court has said.
Court has said. Now, let's kindly come to paragraph 2.17. After putting them through the mock test, the answer scripts were compared with the original ones. Paragraph 2.17. After putting them through the mock test, the answer scripts were compared with the original ones. It was observed that all of them have performed significantly well, almost in line with their performance shown during the original examination. In spite of the fact they wrote the paper in from several months after the original examination was held. They have admitted nothing has been found out in respect of their marks. Now, Lordship, kindly come to page paragraph 2.18. Discussion 3, serial number 3. There is no such allegation that there is a leakage of answer paper and question paper or any manipulation is there. The main materials they have found out that setting a high standard of question paper. This is not lookout of the business department. Fixing of wrong pass mark. Fixing wrong pass mark for reserve category candidates. Improper valuation of the answer scripts. Well, vigilance is not the expert to assess the answer scripts. They are not the technical expert in respect of that. There is a selection committee. Therefore, on that score, my lord, vigilance cannot interfere. On the basis of this observation, your lordship will not find anything that there is an allegation of leakage of question paper or there is a favoritism or there is a glaring malpractice is there. Only in respect of such things, my lord, vigilance can interfere and recommend for cancellation. Nothing is there in respect of that. And not only that, my lord, if that be so, now lordship kindly see the improved order which was challenged before the learned tribunal, internal page 2, paragraph 2 of the order itself. Just 4 lines order is there. With the order of so-and-so, GM Southeastern Railway communicated by Senior DGM GRC, by this confidential letter number so-and-so, the selection for filling up the post of material clerk in store department so-and-so to LDC circulated by this office so-and-so is hereby cancelled.
No, what about your MA application that has been dismissed?
MA application we have filed, we have stated, my lord, that the applicant, respondent filed application for MA petition.
Where is that page?
But I have filed one written notes of argument that I have stated.
Written note of argument.
Paragraph 11 and 12.
10, 11, 12.
10, 11, 12 we have stated, madam.
Yes. Paragraph 10.
Early hearing and to keep the written test in abeyance.
Then what happened? What order was passed?
The applicant respondent had also filed, but
no order.
No order has been passed.
So how can that be? No order can be because in the final order there is no reference of these MA applications.
The tribunal did not interfere of the Senate.
Did not interfere. Where do you have said?
That is page 11, paragraph 4, page 11 and 12.
Page 11 and 12 of?
These are paragraph 11 and 12, page 4.
10, 11, 12.
10, 11, 12. Since my retirement age is earlier, that is why I filed an MA for early hearing to decide the issue.
Where tribunal did not. What you are saying, paragraph 12, tribunal after hearing both parties had declared that 19 posts which had been kept aside should be filled up after finalizing the selection process. Tribunal has allowed the file.
That is the final order of the time.
Tribunal knew that 19 posts have been kept aside.
Yes. But throughout the career, I was in the group before. That was my first and last chance during my career.
This junior become senior clerk.
What benefit you will get, Mr. Das?
Only benefit regarding refixation of
So who will give that to you? You are not in appeal.
I am not in appeal, but they have delayed in respect of that. 2016, after 3 years, 4 years, they have cancelled the selection process.
Yes.
When I will be returning very soon.
So
immediate I have approached before the learned tribunal. I have not taken any late. Immediate mother. Immediate after cancellation, I approached before the tribunal. And tribunal setting aside this order, and they got some time.
1 month, 10 days.
1 month, 10 days. They did not prefer any appeal before your lordship, my lord. Lordship, can you see when they have preferred any preferred the WPCT before your lordship, mother? The WPCT of 1/1/13 of 2022. After the lapse of dividend, after the lapse of some time of the order passed by this
now
tribunal.
what is the law? Suppose today this order is upheld.
Yes.
And if they do not, when they will go for compliance of the order, for compliance of this order, they cannot take you into consideration because you have already retired.
I may be already retired, madam, but taking into that selection process, they can pass appropriate order. Whether I will get it or not, they will consider my case in accordance with law.
What accordance with you passed the written test?
Yes.
Thereafter no interview was held.
Interview process has been over. Interview is not the criteria. Only on the basis of service record.
Service record.
Scrutiny of service record. That procedure was changed. There is no interview at all. Only they will verify the service record in respect of my performance throughout the career. And there is some marks. After scrutiny of service records, my lord, they will consider my case in accordance with nothing more. I will get some depiction of pension. If there is an interview, my lord is right, my lord. I have no case at all. But there is no interview at all.
Interview already abolished.
Already abolished, my lord, by the railway board.
Yes, I can take order. Order of selection. Interview has been abolished.
We have only one copy, the railway board circular regarding the abolition of the interview.
বাড়িতে আছে
ও তো বলছে ও এভিডেভিটে লিখেছে ওর এভিডেভিটে লিখেছে
service record, that is also one bar.
Scrutiny of service.
অন্য লেভেলে এটা কি বলছে
These 19 vacancies were kept aside. This fact we find from which order? There must have been an order that 19 vacancies you do not fill up.
Yes.
They have declared.
When the new
They have declared. They have kept aside that post.
No,
Because of the needs of the application.
No, that was not by virtue of any order of the tribunal.
They have
That is the order in the final order they have stated. In the final order itself.
Final order stated that 19 vacancies are there.
Yes. We kept it.
You kept it aside.
Yes, to process to be within 2 months for filling the 19.
In general, page 5.
Where is that? Where do we find that there was no interview but scrutiny of records? You have stated somewhere, na, Mr. Drulia?
Yes, my lord. That is 2003. There is a circular my learned friend has produced. In notification, it was interview, but subsequently my learned friend produced one circular of railway board that the interview will be substituted by this scrutiny of record in the selection process. So therefore,
that was referred to before the tribunal.
No, it has been not referred. For the first time, this document has been produced before your lordship. So 15 marks still has to be, because the process is to be completed within 2 months with regard to the 15 marks. A scrutiny of the record has to be done within 2 months. If it is not interview, then a scrutiny of the record. Unless that is done, process is not complete. Then that process, then selection will be made as per the order.
Today also you cannot conduct any interview for those 19 vacancies.
Because nobody is now claiming.
Abolished.
Yes.
Nobody, all of them, most of them has taken participation in the subsequent process.
Subsequent, and they have been already.
But 19 vacancies are still there.
Still,
You
yeah,
yourself,
yes.
you have kept
Yeah,
it aside.
yes, yes. Those have not
He
been
has
filled.
he has obtained almost 67.5 marks, second highest marks in that written test.
Yes.
Now, Mr. Drolia, you will throw him out.
Entitlement. Here,
Entitlement, the
here, my lord, the prayer in this, my lord, original application. Kindly have a look, my lord, the prayer.
Yes.
Eight page, my lord. Page 30. Para 8. The court cannot go beyond prayer, my lord. The prayers, relief prayed for.
Yes.
My lord, in view of the facts mentioned above, in para 4, the applicant prays the following reliefs.
Yes.
A. Office order ACR/KDAS/staff/210/M clerk /97 dated 5/4/2016 issued by the assistant personal officers on behalf of the deputy chief material manager Kharagpur cannot be sustained in the eye of the law, therefore be set aside. This has been set aside. This has been set aside.
So
Okay.
this
Then
was
next.
in 2016.
Allowed.
This has been set aside.
Allowed.
Their prayer was that because you set aside in 2016, written test was 2013.
Yes.
You yourself kept the matter pending.
And then, my lord, what is the B, my lord? An order to issue directing the respondent to finalize the selection process for the post of material clerk, since the cancellation is arbitrary. The selection process is to be completed. The prayer is to complete the selection process.
Scrutinize her records. You scrutinize his records.
My lord, here I have challenged that order. I have challenged that order, and my lord, the tribunal passed the order, set aside the order of the the assistant personal officer, and then said you complete the process within 2 months regarding the 15 marks. So 2 months and before expiry of that, the respondent already retired, and then, and moreover, the railway also preferred an application also here.
For what?
Challenging the order of the Central Administrative Tribunal. So where the right accrues?
No, you are taking advantage of the situation now. Now you are taking advantage of the situation that the person has already retired. How can he get? How can what remains in the matter?
The respondent could have participated in that as others participated.
You yourself, you have kept 19 vacancies aside. You yourself, you have kept.
That is the.
You could have merged that with the. We were thinking that that has been taken over in the next selection process.
No, because matter was
that has been clubbed. That has not been clubbed together in the fresh selection process. 19 vacancies are remaining. We understand your challenge. Your challenge is that the vigilance report, on the basis of the vigilance report, we have cancelled.
Yes, the subordinate law. The general manager has been empowered. If finds any irregularities, can cancel the written examination.
What is the irregularity to be for vigilance inquiry? Where is the complaint? Tell us. On the you said in the argument that there were several complaints. As such, we undertook the interview. Not a single complaint you have referred to in your report.
Kindly have a look, my lord, the beginning.
Yes,
from the
we
beginning.
are having a look.
Source.
Where is the complaint? Show us.
My lord, source. First source. Final investigation report.
Yes.
Source. Taking cue from source information.
So there was no complaint. On source information you conducted. On source information, there is no allegation that there was leakage of question paper. There is no allegation to the effect that somebody has been given additional benefit. This poor person, he has appeared, he got 67.5 marks. Now you are taking the point, the person has retired. What he will do now?
Here, my lord, the source is, my lord, on the basis of some information from the
What is the information?
that my lord, taking cue from source information,
This is
a
a very
preventive
random
check was
observation.
conducted. My lord, some source was there, my lord.
What is the
was
source, sir?
conducted at APO store Kharagpur office on departmental examination conducted recently by Deputy Chief Material Manager Kharagpur office for the post of material manager material clerk in its own depot.
Mr. Rolia, vigilance inquiry is on the basis of a fraud practiced, or there is leakage of question, or somebody has been shown favoritism, somebody has been given more marks. These can be the avenue on which the written exam vigilance can enter. But whether the question paper ought to have been of lesser standard or not, vigilance cannot ascertain that. That is for the recruitment committee to do. So,
this is entirely, my lord, the
you
discretion
are an
of the
officer of this court. You
discretion.
tell us, Mr. Jolia, today if there is a leakage, that is why we wanting to know the vigilance. If there was a leakage, we could have understood. What are your allegations against illegalities? Your illegalities are threefold. Once, the cutoff mark ought to have been lowered.
Yes.
Cutoff mark ought to have been lowered. The answer question paper ought to have been of lesser, of not so strict as it has been given. That is not a subject matter of vigilance.
My lord, the discretion of the general
Give
manager.
him the benefit. Give him the benefit, scrutinize his records. If he has retired, only what remains is scrutiny of records. Marks he has obtained 67.5.
My lord, now there is no tenure. No tenure
No,
left.
we will not ask you about the tenure. We will not ask you about the tenure. Suppose today we do not interfere, contempt application will follow. You have to go and comply. You have given the retirement benefits to him. Only what remains to be, as you have said, only what remains to be clarified is how much marks he will obtain in scrutiny of records. Now, if the scrutiny of records is found, the thing is, if he secures a particular mark, then he becomes entitled. Now, the person has now retired. On notional benefit, you will give the pensionary benefit. You will fix the pension at the grade of a Group C staff, and all notional benefits you will get. The pension amount will enhance now.
Well,
He was getting 500, he will get
I will
600.
take instruction.
No instruction. We are passing our order. Huh? তাই বলে দিই, huh? You have got what? Have you got pension?
I am getting pension in respect of group people.
That has been sanctioned in your favor. Now the thing is, suppose we hold in your favor. In that case, these 19 vacancies, if the tribunal order is to be complied with, these 19 vacancies have to be filled up on the basis of the earlier selection process. Cancellation goes. Now, in the earlier selection process, all the persons who applied, they have now gone elsewhere. Now, how they will fill up 19 vacancies?
Nobody has come before this tribunal except myself.
That is because you did not participate in the next selection.
Because I have challenged, because I have got 67 point something marks.
Then how they will, what process they will undertake to fill up these 19 vacancies?
Nobody has come before this court, therefore nobody has got a right to file any application. That is number one.
What have, we are asking 19 vacancies are there. Tribunal says you fill up those 19 vacancies. What is the direction? Fill up, select, and finalize the selection. Now, how they will finalize?
I am just paying before a lawsuit. My service record, they may be scrutinized. If I form eligible, they will get the benefit.
How they will find you eligible? Suppose the persons who 28 persons applied.
Yes.
Out of 28 persons, almost all of them have got appointment.
Promoted. Therefore, nobody will come before this court or anywhere else because they have already participated in subsequent selection process. Except me, I have challenged the process of selection.
Right. How they will fill up these 19 vacancies?
But they will only consider my case. This cannot be a precedent. My lord can state it in this order. This order cannot be set as a precedent because nobody has challenged. Myself has challenged. Those who have come before this court, I will get the benefit in respect of the judicial order. If they do not come and they have choose for participating in another selection process, it is their fault. If I have come, my lord, I have succeeded in the lower forum, where the tribunal has granted some relief.
You, Mr. Das, 19 vacancies are there. Tribunal says that you finalize those 19 vacancies.
No one claim.
Where from they will finalize that selection process?
There are no one to claim.
But my lord, already it is their submission. Except the applicant, all of them participated and they are promoted also. They are enjoying the higher benefits. Therefore, nobody will come. Already they have got the benefit. Except me. I was the victim in respect of the action of the respondents. But kindly consider this aspect. There is nothing is there. In the cancellation process, my lord, the business has initiated, nothing is there. No incriminating materials are there. But there is a gross irregularities, malafide, favoritism, leakage of question, but nothing is there.
চ্যালেঞ্জ করে finish off the problem.
Here, my lord,
If he has already retired.
He has already retired.
So nobody else will go and file contempt against you.
Contempt was filed by my learned friend.
That will be there. That right now lawsuit can be disposed.
We will say he will not proceed with
yes.
Contempt filed by only if you give him the benefit, what is the benefit? This is only the benefit, what benefit you will get. He has got the payment as Group D staff retired. You will fix his pension on the basis of Group C post, notionally. And
you kindly fix it for orders, my lord. Kindly fix it for orders.
You kindly ascertain this.
Yes.
Whether
from the railway, I will ascertain. Can it be whether
if that is done, his purpose is served.
Yes, I will.
He will get the. He has retired on 22nd of
February.
28 February.
28 of February. 8 page 41.
Wait,
22.
How much pension he is getting? Group C post.
I am getting group D post pension.
Are, where is that? Where is your pension? Have you seen that, Mr.?
15,500.
15,500.
15,500 basic.
Basic pension 15,500. In respect of group D post.
So that comes to, that is basic. Then he is getting almost 25,000. How much pension he is getting?
Total pension
for the fund.
With TA now in hand, 15,861.
Why basic? That is the takeaway income.
Including all 15,861.
All right. Now, if he gets Group C, what will be his pension? How much?
কত টাকা হবে গ্রুপ সি হলে? গ্রুপ সি হলে কত টাকা হবে?
Calculation করতে
It is around 20,000. Some pay scale will be higher. The group D to group
What
C.
is the Group C? What is the Group D pay scale and Group C pay scale?
Group D pay scale is the pay scale is group C 5,200 to 2,200. With gateway of rupees 1,900.
Huge amount, huge difference, my lord. 20,000. This is there.
Difference.
Huge difference. That is, my lord.
8 to 9,000 difference will be there.
Huge difference. That comes to 20,000.
Das, you have not preferred any appeal. You should have come before your relationship ended. The person has unnecessarily suffered.
No, the tribunal said to process the selection. They did not done so.
Now, if this writ petition is dismissed, what benefit you will get?
But immediately I shall file another application before the tribunal to give the consequential benefit. Only thing I can do.
What consequential benefit? No selection and consequential benefit.
67 marks I have got. Only scrutiny of records they will give. Nothing more. Nothing
Now on
more.
scrutiny of record, you get one. With whom they will compare?
Even that I will pass. Even that I will pass. Even I get the one. 67.5 marks.
No, 67 mark out of 85.
5,000 pay band, my lord. Pay band is
Minister fill up করার জন্য তো লোক নেই।
5,200
Mr.
to
Mr.
20,000.
Yeah, please take instruction because today if this 19 vacancies finalization remains, you will suffer problem because the contenders for those posts are not there. They have already been promoted.
Yes, already absorbed.
Right. So this 19 vacancies, you have to put that into some other vacancy and fill them up. These 19 vacancies, tribunal order, if you go to comply tribunal order, how you will comply, tell us? Because the persons who applied, those persons have already been promoted.
Well, tribunal order now merged with your lordship's order. It has come before your lordship.
That's why we are saying
My
that.
lord,
Is why
yes.
today, what is the difficult? Your authorities will not apply. You will apply your mind.
My lord.
This 19, suppose today, the order is set aside, your application is allowed. Then everything goes. But if this process of selection with 19 vacancies, you yourself kept it aside. You have said, I am keeping 19 vacancies till the finalization of the original application. Now, how you will fill up 19 vacancies? There are no contenders. Only give him this benefit and finish it off.
My lord, 19 vacancy kept aside. Certainly in future, my lord, whenever there is such occasion, my lord, railway will conduct examination for filling that.
All right, the learned advocates appearing for the respective parties have concluded their arguments. Stop. List the matter as for orders in the daily supplementary list of this court on আজকে কি আজকে the second as fixed at 1 p.m. We will pass our order. Or sorry, on 24th.
24th January and 24th December.
24th this week. Because my
Yeah.
brother will not be
Oh,
there.
24th this, Milord.
We will finish up the.
Milord, I have to take instruction that whether can be, whether, but there is a difference a lot. Milord, here the pay scale is 5,200 to 20,200. So they will be very, if it is a small difference, Milord, I could have understood.
You take instruction
Milord.
or we will pass. Okay. Now, no area, nothing. No area, nothing. Because had he been successful, your declaration was 2016. He would have earned salary for more than 5 lakhs. Had he been appointed at Group C at that 2016.
Or he could have participated in 2019. He was a very good, he knowledge maybe the good, so he got the good marks.
No,
So he could have,
if he had obtained only 2 marks in written test, we could have considered.
Yes.
It was a difficult question paper according to you. He still contested. He contested, he secured the second highest marks. And we are the rich court.
So at least 2019, he would have applied.
No,
So by
Mr.
this time,
Jodia,
2019 seniority would have come.
oh, that his advocates have advised. Don't participate. We will see.
Rather, he made a miscellaneous application for stay of that, examination, written examination, selection process.
You show us that that pay order was that application was rejected. Had the application been rejected, you would not have kept 19 posts apart. You have kept 19 posts apart. Or you take the small instruction on we will pass our order.
Hello.
Yes, next.
It will appear for order.
In 14 minutes, I am for the respondent.
Yes, it is that. Have you checked up, Mr. Vajpayee?
Yes.
2 names were given.
Yes. Under the instruction that I have received from the authority,
What is the instruction, Mr. Vajpayee?
my lord, the question is, my lord, that in 2010 circular, there are certain preconditions. One is that one is to be displaced from the place of residence and government land, whether he has received or not. Lordship, kindly have a look to the instruction that I have received.
Where is your other side?
Other side, she was waiting, but possibly she has thought that today it will not be taken up.
All right, we take it up tomorrow.
Tomorrow. That will be.
Yes.
She was here for since morning like me.
But এই যে যেটা শুক্রবার ফরওয়ার্ডার সে হলো না ওইটা একটু আমাকে
Next is also I am for the respondents. No, that I have received instruction.
15, I am appearing for the petitioner, Your Lordship.
It is that matter where they are to file a contempt application before the tribunal, but instead, Your Lordship, it fell from Your Lordship that if you can do anything or take instruction from the authority, whether the question can be resolved at this stage instead of going to contempt in the tribunal.
tribunal's order has not been complied with. So it fell from your lordship, then you should file a contempt application before the tribunal, not here. And your lordship's pleasure was to engage me by court's order to do something on earlier occasion.
What was the matter for? Matter was for
Lordship, for family pension, which was not being released since 2015. 2015, the petitioner's father has died, and petitioner has applied for the family pension, but it was rejected on the ground that the
petitioner's father.
So petitioner.
You are the son. You are the son.
No, she is the daughter.
She is the daughter.
Unmarried daughter.
Unmarried daughter, Lordship.
So you applied for
Family pension, Lordship.
Then what happened?
And they have rejected on the ground that the service book cannot be found of late Dinesh Chandra De. Then the petitioner filed the original application before the learned tribunal, your lordship. And in 2016,
85 he retired. He was not getting pension?
Yes, he was getting pension, your
When
lordship.
did he expire?
He expired in 2015, and his wife earlier died on 2011, lordship.
All right. The response submitted furnished. Do you have any other brother and sister?
Lordship, I have 3 other brothers. They all were government employees, and I have the no objection certificates from my brothers also, that they have no objection if the family pension is being issued in my name.
Now, who has preferred this epic? Why you have this order is in your favor?
Yes, lordship.
Then why have you preferred this writ petition?
Lordship, your lordship has on the earlier occasion has suggested me that I should have filed the contempt application before the tribunal, lordship, because the statutory period was being exhausted. That is why I have preferred this writ petition. Your lordship has considered my prayer.
Extend the time.
Yes.
We will extend the time for consideration.
I think that
Lordship, lordship, on the earlier occasion, your lordship has.
Mr. Bajpayee, give the family pension.
My lord, I have repeatedly told them
What is
that they are simply saying that few documents that is to be served, because to save the guideline, this is the instruction. Lord, you kindly see the last page of the. I requested them rather. Why don't you release this legible pension? She is eligible for that. Last page, Lordship, kindly see of the instruction.
Last page.
Last page.
Oh, they will never do it, Mr. Bajpayee.
That's why, my lord, I was suggesting my junior friend to file a contempt by waiving the limitation period. Because if contempt is filed, in that event they will jump upon the area and they will because again he is saying that everything has been submitted, but as per her it is already submitted. But the authority is saying that these are the documents to be required for the purpose of release of pension. So, my lord, this conflict will never end. So, what I respectfully submit, my lord, let him be within the original side jurisdiction because before the tribunal, and your lordship may kindly extend the limitation period.
Lordship,
That will be better.
It's been
Otherwise,
8 years, lordship, that, and the petitioner is an old lady of 57 years of age, lordship. So and it's been almost 1 year after the order of the learned tribunal, lordship, and they are a time and again they are asking for the documents, lordship.
Where from he will?
I
get
am
the
in
doc-
deep mind to release the pension, my lord. The question is, my lord, the authority has given me a specific instruction that these are the documents required, my
Lordship,
lord.
we are ready to
That's it.
submit these
So,
documents. Again, we are ready to submit these documents if they
Which
are.
documents you will submit? They have asked for documents. Those are at page
Lordship.
50. Page 53.
Lordship, I don't have the
Page 55.
55.
Of your
Of
writ petition.
writ petition. Lordship, that documents I have already been submitted, Lordship.
You have
They have
submitted.
again they on 7th July 2023 they have asked for few documents, Lordship, which were
7th of July.
July 2023, which I do not have the copy annexed in this writ petition, Lordship.
That memo.
It is also lied on. It is
7th
in the
of July.
instruction, Lordship.
that is within with the instruction.
You have got that copy. 7th July.
Yes, I have the copy, but I could not
Have you
annex it.
spoken with your client that does he have these documents?
Lordship, if you can see, Lordship, kindly that in these documents, Lordship, they have asked for the Form 3, which I have already submitted, and they asked for some affidavits, no objections from the other siblings, which I already have been submitted. Only there are some rectification, Lordship, about the designation of our father, which I can do within 1 or 2 weeks, Lordship.
How will you rectify? Those records are not with you.
Lordship, they have asked for
Designation is mentioned as UTC.
UDC in my siblings first class magistrate affidavits, Lordship, which can be rectified by the petitioner, Lordship.
I see. Now, name of wife of late Dinesh Day and does not tally with PPO.
Lordship, this is something that the petitioner or her siblings do not have any not PPO, Lordship, the Aadhaar cards or voter cards, identity cards of their mother, because she has passed in 2011, Lordship. And on the PPO, maybe her name was mentioned as Shudha Rani. And on the death certificate, Lordship, it has been mentioned as they. Which normally, Lordship, every woman who is married has the name, middle name, which is Rani, which could have been mentioned in the PPO, Lordship. But that we do not have any identity card lies with us of our mother, of the petitioner's mother.
This has been communicated to you 7th July.
Lordship, but the petitioner forgot to provide me before filing this writ petition, Lordship. That is why I could not have annexed it with
No,
the.
it has been served upon them. It has been served.
The instruction?
No, it is.
Yes. Served, but the petitioner did not provide me at the time of filing of this writ petition, Lordship.
So with whom she will go and meet Mr. Bajpayee? You tell
No,
us.
that's why, my lord, I was beseeching your lordship, my lord, either to release the pension, and these are in terms of the documents asked for, without going into the with the specific part, that is, or
no, that is not the order of the tribunal.
Yes.
Said considered.
Yes.
These people, the lady will die. Now, if we leave it, it will go to contempt. We are a writ court, Mr. Bajpayee.
Yes.
When there is no actual, this officer, why he is raising
Yes,
this?
well, I am also confused to what to do. I want to help her, but the question is, that's why, my lord, immediately as it fell from your lordship, my lord, I asked for instruction. Why it is not paid? Why you are harassing the people?
Lordship, I have also made the party the pay and accounts office, Lordship.
Pay and accounts will not help you, madam. It is for you are.
They have returned the application, Lordship, and the
return good.
Returned because of non-furnishing of documents.
পিটিশনার এইগুলো দিয়ে দিয়েছে, আবার ফার্দার ডকুমেন্ট চেয়েছে। হ্যাঁ, এগুলো অলরেডি দিয়ে দিয়েছে। শুধু রেকটিফিকেশনটাও করবে কি করে? ডেজিগনেশন নো অবজেকশন যেটা, সেখানে রেকটিফিকেশনটা নয় করে দেবে, আর ওয়াইফের ডেথ সার্টিফিকেটে ইয়ে নেই সেটা করে দেবে। Unless you keep the matter pending, হবে না। You don't have the PPO copy?
Lordship, I have the PPO copy, but I do not have the service book or the Form 3 which have been submitted by the deceased, which they have asked for, but they have mentioned a clause which I can do that.
No, Form 3 you have already submitted.
Submitted from my end, from petitioner's end, Lordship, but they have asked that the Form 3 submitted by the deceased, which I do not have with me, but they have mentioned a clause which can be submitted by me through a affidavit, Lordship.
You may get the copy of those Form 3 from respective department. Office of the
Yes, that I was saying.
From the
Yes,
those documents.
my lord.
We are keeping it after 2 weeks. You prepared this affidavit.
Lordship.
This first affidavit, second affidavit, you prepared.
Lordship.
Copy of Form 3 submitted by deceased government servant, that is not with you.
Not
now you have to file an affidavit.
affidavit, Lordship.
Yes.
That I can do, Lordship. I have already submitted the Form 3, but not in the form of a affidavit, which I can submit within 2 weeks, Lordship. Lordship, if you can see, it is in my writ petition, Lordship, at page
Form 3 by the
deceased, but which I do not have. I have.
You go through this letter, you come and tell us which clauses you can comply. Otherwise, again, you will be creating problem.
Lordship, only the 4th point, Lordship, that the wife's name, which they have said that are not tallied, but
death certificate you have.
Death certificate I have, Lordship.
That wife's name is
mentioned as they, and which
she had it because that is why they.
Yes, Lordship, but
What
they
was her spinster name?
Spinster's name, I don't have the knowledge,
She was,
Lordship.
you are an unmarried daughter. There's a name of wife of late Dinesh in death certificate and do not tally with PPO book.
PPO book, Lordship, but the PPO book has the name of Rani, Sadhana Rani, and did not mention the surname of her husband. That is they, Lordship.
That is not there.
That is not in the PPO book. There it was only mentioned as Sadhana Rani.
That also requires one affidavit that this
But
they are
mother
sent
has already died, Lordship. How
mother? We have to
died, Lordship. Only the 4th point, Lordship. The other requirements I can fulfill within 2 weeks, Lordship.
You come then after you come you come with the affidavits. We will send him to meet with the officer. With the affidavit, she will go, and this officer, this we will say this name of the wife, how she will change.
She will change, yes.
How she will change.
Definitely. Mother from our mother station.
So
that is to be relaxed because the daughter can make an affidavit stating that my mother's surname is this.
No, that can be relaxed. With all your siblings, you make an affidavit.
Yes.
Affidavit, Lordship.
Saying that in the death certificate, the name of my mother has been incorporated as Sadhana Rani instead of Sadhana Rani De.
Lordship. That I can.
As she is seeking family pension from the deceased employee, since he is they, therefore it is automatic that her wife should be they.
You affirm these 3 affidavits.
Lordship.
And bring it before us.
Lordship. Lordship.
Correct.
Bring it. In course of hearing, Mr. Bajpayee, learned advocate appearing for the respondents, has placed before us a memo dated 7th of July 2023, by which the respondent number, who is this Mr. Bajpayee? Who is this officer? কার্যপালক সব হিন্দিতে বলতে হবে।
He is the executive engineer.
কি লিখলে in course of hearing?
Respondent number 5.
Respondent number 5.
Lordship, may I submit a humble prayer, Lordship? On the death certificate in Sadhana De, Lordship, it has been mentioned that wife of Dinesh Chandra De. It is clearly evident from the death certificate itself that she was the wife of late Dinesh Chandra De, Lordship.
That is true.
Why stating that fact you still affirm an affidavit?
Lordship, surely.
First, you will go to the executive magistrate, you affirm 3 affidavits. Bring it before us, then we will ask Mr. Bajpayee.
Lordship.
In course of hearing, Mr. Bajpayee, learned advocate appearing for the respondents, has placed before us a memo dated 7 July 2023 issued by the respondent number 5. By the said letter, the petitioner has been asked to submit the documents incorporated, have been asked to submit further documents. Stop. A copy of the said letter has been handed over to Miss Das, learned advocate appearing to the petitioner in court today. Stop. She prays for Miss Das prays for an accommodation to avail necessary instruction. Stop. Please the matter for further consideration in the daily supplementary list of this court. On. How long will you take?
Lordship, within 2 weeks.
তাহলে আছে কত তারিখ? 22, 29, 6 তারিখ করে দাও।
My Lord, instead of 6, my Lordship, kindly make it 7th.
7th. চল।
Deeply obliged, Lordship.
Thank you, Mr. Bajpayee. এইটা মিস্টার বাজপেয়ীকে ফেরত দিয়ে দাও।
My Lord, I wholeheartedly tried to assist her, but
that has not, she will bring the evidence. We will make the appropriate observation so that you can bring the. Do you have a copy of that letter?
Yes.
Extra copy do you have? So please give us on record. Only that letter will do. Last page.
My Lord, I have handed over. I have handed over.
Placed before us, he has placed before us a letter dated at has placed before us. It's a learned advocate appearing for the respondents. Has placed before us a letter dated such and such issued by the respondent number 5. Let the same be kept on record. তারপরে লিখবে by the said letter. Pen drive পাঠিয়ে দেবে correction.
Deeply obliged.
Yes. Yes, you are waiting from the morning. Which matter?
No, because I have this case only, so what is the next day? Tomorrow I will do that.